boring. Hurmatli tadbir ishtirokchilari, xalqaro tadbirimiz boshlanishiga 15 daqiqa vaqt qoldi. Iltimos, o'z joyingizni egallab oling. Hurmatli tadbir ishtirokchilari, tadbirimiz boshlanishiga 15 daqiqa vaqt qoldi. Iltimos, o'z joyingizni egallab oling. Hurmatli xonimlar va janoblar, tadbirimiz boshlanishiga 10 daqiqa vaqt qoldi. Iltimos, o'z joyingizni egallab oling. Hurmatli mehmonlar, tadbirimiz 10 daqiqadan so'ng boshlanadi.
Уважаемые участники форума, убедительная просьба занять свои места. Буквально через 10 минут мы начинаем наше мероприятие. Благодарим за понимание.
Четыре, пять.
Hurmatli mehmonlar, tadbirimiz 5 daqiqadan so'ng boshlanadi. Iltimos, o'z joyingizni egallab oling.
either dozing or being jolted awake by pangs of hunger or in worries and vague hopes, all of which, however, led to the conclusion that for the time being, either dozing or being jolted awake by pangs of hunger or in worries and vague hopes, all of which, however, led to the conclusion that for the time being,
Hurmatli tadbir ishtirokchilari, tadbirimiz boshlanishiga sanoqli daqiqalar qoldi. Iltimos, yo'lakdan asosiy zalga kirib, o'z joyingizni egallashingizni so'raymiz. Дорогие гости, буквально через 5 минут начинается наше мероприятие. Убедительная просьба, займите свои места. Hurmatli mehmonlar, tadbirimiz yo'lakdan siz kirib, asosiy zalda o'z joyingizni egallab olganingizdan so'ng boshlanadi. Iltimos, asosiy zalga kirishingizni so'raymiz. Дорогие гости, убедительная просьба, займите свои места. Наше мероприятие начинается через несколько минут.
Dear guests and participants, please take your seats. Уважаемые участники, мы начинаем. Просим всех занять свои места. Давайте сейчас всех.
Hurmatli tadbir ishtirokchilari, tadbirimiz 1 daqiqadan so'ng boshlanadi. Iltimos, so'nggi bor o'z joyingizni egallab oling. Assalomu alaykum, hurmatli tadbir ishtirokchilari. 4-bor o'tkazilayotgan an'anaviy Toshkent huquq bahori xalqaro yuridik forumiga xush kelibsiz. Barchangizga ma'lumki, xalqaro va milliy yuridik hamjamiyat uchun huquqning zamonaviy tendensiyalarini muhokama qilish va o'zaro fikr almashish uchun qulay maydonga aylangan ushbu forum 2019-yildan buyon o'tkazib kelinmoqda. Mazkur forumni nafaqat huquqshunoslar, balki tadbirkorlar, davlat xizmatchilari va siyosatchilar uchun ham innovatsiya, tajriba va hamkorlik platformasiga aylangan desak xato bo'lmaydi. Shu munosabat bilan forum ishtirokchilariga O'zbekiston Respublikasi prezidenti Shavkat Miromonovich Mirziyoyev tabrik yo'llagan. Forum ishtirokchilariga mazkur tabrikni o'qib eshittirish uchun sahnaga O'zbekiston Respublikasi prezidentining maslahatchisi Davletov Ruslanbek Quroltayevich taklif etiladi.
Assalomu alaykum, hurmatli forum ishtirokchilari. Tashkent Law Spring 4-xalqaro yuridik forum ishtirokchilariga, hurmatli forum ishtirokchilari, hurmatli mehmonlar. Avvalambor sizlarni raqamli texnologiyalar davri kelajakka huquqiy nazar mavzusidagi Tashkent Law Spring 4-xalqaro yuridik forumining ochilishi bilan samimiy qutlayman. Anjumanda jahonning nufuzli tashkilotlari va 40 dan ortiq davlatlardan yuqori martabali delegatlar, yetakchi oliygohlar va aql markazlarining taniqli olimlari va ekspertlari ishtirok etayotgani uning nufuzi va ahamiyati tobora oshib borayotganiga hol ko'rsatmoqda. Yuksak texnologik taraqqiyot jarayonida inson manfaatlari va adolat tamoyillariga amal qilish, samarali huquqiy mexanizmlarni yaratish, raqamli suverenitetni ta'minlash bo'yicha xalqaro hamkorlikni har tomonlama kuchaytirishni davrning o'zi taqozo qilmoqda. Texnologiyalar va virtual munosabatlar shiddat bilan hayotimizga kirib kelayotgan bugungi kunda sun'iy intellekt kabi taraqqiyotning eng ilg'or yutuqlarini bashariyat manfaatlari yo'lida oqilona va samarali foydalanish zarur deb hisoblaymiz. Yangi O'zbekistonda raqamli texnologiyalar yordamida davlat boshqaruv modernizatsiyasi va davlat xizmatlarini elektronlashtirish, ochiqlik va shaffoflikni ta'minlash hisobiga xizmat ko'rsatuvchi davlat tamoyilini ro'yobga chiqarishga katta e'tibor berilmoqda. Oddiy odamlarga keng qulayliklar yaratayotgan sun'iy intellekt hayotimizga chuqur kirib kelmoqda. Shuni inobatga olib, biz sun'iy intellekt texnologiyalarini 2030-yilga qadar rivojlantirish strategiyasini qabul qildik. Onlayn rejimda ishlovchi platformalar hamda integratsiyalashgan bilimlar bazalarini ishga tushirdik. Shaxsiy daxlsizlik huquqi va taraqqiyot ehtiyojlari o'rtasida nozik muvozanatni topish, intellektual mulk himoyasi, sohada qulay investitsiyaviy muhitni ta'minlash, shuningdek yangi voqelik, raqamli dunyo sharoitida davlatlarning huquqiy transformatsiya jarayonlariga muvaffaqiyatli o'tishi, ayniqsa sun'iy intellekt yo'nalishida tizimli hamkorlikni kuchaytirish va undan foydalanish etikasi bo'yicha namunaviy qoidalar ishlab chiqish ustuvor ahamiyatga egadir. Ushbu innovatsion huquqiy asos mazkur sohani samarali tartibga solishda barcha davlatlar uchun o'ziga xos namuna bo'lib xizmat qilishi shubhasiz. Forumda ana shu muhim jihatlarni alohida hisobga olib, eng dolzarb masalalar muhokama qilinishi hamda amaliy taklif hamda tashabbuslar ishlab chiqilishi raqamli kelajakning mustahkam poydevorini yaratish va raqamli transformatsiya yo'lida yana bir muhim qadam bo'ladi deb ishonaman. Anjuman doirasida ilk bor yoshlar forumi o'tkazilayotgani ham diqqatga sazovordir. Chunki bu sohalar rivojini yosh avlodning faol ishtirokisiz tasavvur etib bo'lmaydi. Zero navqiron huquqshunoslarning innovatsion g'oyalarini qo'llab-quvvatlash va ularni qonun ijodkorligi jarayoniga keng jalb etishda bunday samarali muloqot maydonlarining ahamiyati g'oyat kattadir. Ana shunday ezgu ishlarda sizlarga kuch, g'ayrat, mustahkam sog'liq va yangi yutuqlar, forum ishiga esa muvaffaqiyat tilayman. Shavkat Mirziyoyev, O'zbekiston Respublikasi Prezidenti. Katta rahmat.
Rahmat, Ruslanbek Quroltayevich. Hurmatli mehmonlar, forum ishtirokchilarini kirish so'zi bilan qutlash uchun sahnaga O'zbekiston Respublikasi Adliya vaziri Tashqulov Akbar Jo'raboyevich taklif etiladi.
Assalomu alaykum, hurmatli xonimlar va janoblar, aziz mehmonlar. Algoritm asoschisi Al-Xorazmiy vatani O'zbekistonga xush kelibsiz. Barchangizni Tashkent Law Spring 4-xalqaro yuridik forumida ko'rib turganimizdan bag'oyat mamnunmiz. Forumning faxriy mehmonlari Birlashgan Arab Amirligi Mahkama bosh kotibi va hukumat vaziri Maryam bint Ahmad Al-Hamadi xonim, Malayziya bosh vaziri departamenti huquq va insonal islohotlar vaziri Dato Sri Azalina binti Dato Asmal Said xonim, Qatar davlati adliya vaziri va hukumat ishlari davlat vaziri janob Ibrahim bin Ali bin Issa Al-Hasan Al-Mahannadi janobi, Ozarbayjon Respublikasi adliya vaziri janob Farid Turob o'g'li Ahmadov, Pokiston Islom Respublikasi adliya va qonunchilik vaziri janob Azam Nazir Tarar, Rossiya Federatsiyasi adliya vaziri janob Konstantin Anatolyevich Chuychenko, Singapur bosh prokurori janob Liu Xin Wong, Xalqaro notariuslar ittifoqi prezidenti janob Lionel Messi, Osiyo sud ekspertiza tarmog'i prezidenti Norin Eydora Saydon xonim, sizlarga tashrifingiz uchun minnatdorchilik va alohida hurmatimizni bildiramiz. Shuningdek, forumda qatnashayotgan Birlashgan Arab Amirligi, Vengriya, Saudiya Arabistoni Qirolligi, Tojikiston, Turkmaniston, Turkiya va Qirg'iziston adliya vaziri o'rinbosarlari, 30 dan ortiq advokatura, notariat, sud ekspertiza, mediatsiya, arbitraj va davlat xizmatlari ko'rsatish bo'yicha milliy tashkilotlarning rahbarlari, sizlar ham xush kelibsizlar. Jahon odil sudlov loyihasi, iqtisodiy hamkorlik va taraqqiyot tashkiloti, Oxford Insights, Alibaba Group, Kaspersky kabi kompaniyalar, Harvard, Oxford, Max Planck kabi nufuzli universitet va aql markazlaridan forum sessiyalarida ma'ruza bilan ishtirok etayotgan 100 dan ortiq spikerlarimizga o'z minnatdorchiligimizni bildiramiz. Hurmatli O'zbekiston Respublikasi Prezidenti maslahatchisi, hukumat, hurmatli spiker o'rinbosari, Oliy sud, Konstitutsiyaviy sud, bosh prokuror, vazirlar va idora rahbarlari, sizlarga ham bizlarni qo'llab-quvvatlaganligingiz uchun minnatdorchilik bildiramiz. Forumda qatnashayotgan 1000 ga yaqin ishtirokchilar, shu jumladan 40 dan ortiq davlatlardan tashrif buyurgan 200 dan ortiq huquq, IT, biznes sohasining yetuk mutaxassislariga hamda bizni onlayn kuzatayotgan barcha qatnashchilarga o'z minnatdorchiligimizni bildiramiz. Hamkor va homiylarimiz Birlashgan Millatlar Tashkilotining taraqqiyot dasturi, Germaniya xalqaro hamkorlik tashkiloti, Osiyo taraqqiyot banki, Vincent Elkins, Penna Goldberg, White & Case, Foley Hawk, Dentons, Latman and Watkins, Baker Botts kabi yetakchi xorijiy va mahalliy yuridik kompaniyalar, Navoiy kon metallurgiya kombinati, Navoiy uran, Olmaliq oltin kon metallurgiya kombinati, Yandex, Aquapower, Korzinka kabi mahalliy kompaniyalarga ham bizlarni qo'llab-quvvatlaganliklari uchun tashakkur bildiramiz. O'ylaymanki, 2 kun davomida biz birgalikda forumni mazmunli va taassurotlarga boy qilib o'tkazamiz. Hurmatli forum qatnashchilari, Tashkent Law Spring forumi huquq tizimlari oldida turgan eng dolzarb masalalarni muhokama qilish, zamonaviy huquqiy yondashuv va tendensiyalar yuzasidan fikr almashish, yangi chaqiriqlarni birgalikda javob topish hamda ishtirokchilar o'rtasida samarali hamkorlik o'rnatishni o'ziga niyat qilgan. Navbatdagi forum mavzusini raqamli texnologiyalar davri kelajakka huquqiy nazar deb nomladik. Chunki biz virtual va real dunyo o'rtasidagi chegaralar yaqinlashayotgan sun'iy intellekt va raqamli texnologiyalar tobora insonni o'rnini jadallik bilan egallab borayotgan davrda yashayapmiz. Yangi texnologiyalar yordamida kundalik hayotimizdagi masalalardan tortib global miqyosdagi muammolarni hal qilishgacha yechimini topishda foydalanyapmiz. Algoritm neyrosetlari bugun sog'liqni saqlash, ekologiya, qishloq xo'jaligi, transport, bank va boshqa ko'plab sohalarda nafaqat ma'lumotlar to'plash, tahlil qilish, balki xavflarni baholash va qabul qilishda ham ishtirok etyapti. Xuddi shunday raqamli texnologiyalar huquq sohalariga ham jadallik bilan kirib kelmoqda. Milliy adliya tizimlari, sud, prokuratura, ichki ishlar, adliya organlari, yuridik kompaniyalar, notariat, advokatura sohalari o'z faoliyatlarini raqamli texnologiyalar orqali samarali bajarishni yo'lga qo'ymoqdalar. Umuman olganda, raqamli texnologiyalar bizni har qachongidan tez rivojlanishimizga xizmat qilyapti. Shu bilan birga biz mutlaqo yangi munosabatlar, xavf-xatar va muammolarga ham duch kelyapmiz. Ularga nisbatan an'anaviy huquqiy yondashuv va qarashlar esa har doim ham javob bermaydi. Ma'lumotga ko'ra, o'rtacha inson kun davomida 7 soat, Z avlosi esa 9 soat vaqtini gadjetlar ekrani oldida o'tkazmoqda. Gadjetlar, aqlli uskunalar va ijtimoiy tarmoqlar, sun'iy intellekt, big data, raqamli kuzatuv vositalari orqali insonning shaxsiy hayoti, tanlovi, xatti-harakatlarini doimiy tahlil qilmoqda. Bunday texnologiyalar yordamida to'plangan ma'lumotlar ba'zan inson manfaatida ishlatilish bilan birga unga zarar yetkazish holatlari ham ko'paymoqda. Masalan, generativ sun'iy intellekt va deepfake texnologiyalari rivojlanishi natijasida yolg'on axborotlarni tarqatish, jamoatchilik fikrini manipulyatsiya qilish va hatto siyosiy jarayonlarga ta'sir ko'rsatishi ancha osonlashdi. Bu reallikning o'zi xavf ostida ekanini anglatadi. Odamlar haqiqatni yolg'ondan ajratishda qiynaladi. Natijada jamiyatda ishonchsizlik va bo'linish kuchayish ehtimoli oshadi. Yana bir xavf, kiber jinoyatlar global miqyosda tez sur'atlarda o'smoqda. Ularning iqtisodiy va ijtimoiy zarari yil sayin oshmoqda. Yangi texnologiyalar, geosiyosiy ziddiyatlar, kiber qonunchilikdagi murakkabliklar bu xavflarni yanada kuchaytirmoqda. Bu kabi holatlar fundamental huquqlar, inson sha'ni, daxlsizligi, so'z erkinligiga xavf tug'diruvchi mutlaqo yangi ko'rinishdagi hodisalar hisoblanadi. Agar fundamental huquqlarimiz virtual muhitda ham samarali ta'minlanmasa, inson huquqlari haqidagi g'oyalar faqat nazariy tushuncha sifatida qolib ketishi mumkin. Chunki huquq bu faqat qog'ozdagi qoida emas, balki har bir shaxs uchun real imkoniyat yaratadigan ta'sirchan mexanizmdir. Bugun raqamli dunyoning yangi qonuniyatlari shakllanayotgan bir paytda biz huquqshunos va qonun ijodkorlari huquqiy me'yorlardan qanday moslashtirishimiz, qanday tamoyillar asosida yangilashimiz kerak? Bu savollarga javob topishga forum doirasida urinib ko'ramiz. Shuning uchun forum sessiyalarida raqamli texnologiyalar davrida inson huquqlari himoyasini ta'minlash, sun'iy intellektni huquqiy tartibga solish va kriptovalyutalarni tartibga solish, virtual dunyo va uning ishtirokchilarining huquqiy statusi va nihoyat odil sudlovni raqamli transformatsiyasi kabi mavzularni muhokama qilamiz. Xulosa qilib aytganda, biz bugungi kunning dolzarb, murakkab chaqiriqlariga javob berish uchun birgalikda harakat qilishimiz kerak. Ushbu forum biz uchun g'oyalar almashish, yangi tajribalarni o'rganish va xalqaro hamkorlikni yanada mustahkamlash uchun ajoyib maydoncha bo'ladi. Bizning vazifamiz raqamli dunyoni va uning yangiliklarini qabul qilish. Shu bilan birga inson huquq va erkinliklarini nafaqat offline, balki onlayn tarzda himoya qilishni, huquqiy va institutsional muhitni yaratishdan iborat. Ishonchim komilki, biz birgalikda huquq sohasidagi dolzarb muammolarga samarali yechim topamiz va raqamli dunyoni xavfsiz, adolatli va inson manfaatlari yo'nalishiga imkon beradigan yangi qoidalar va amaliyotlarni ishlab chiqarishda munosib hissa qo'shamiz. Tashkent Law Spring 4-xalqaro yuridik forumini ochiq deb e'lon qilaman. Hamda 2 kun davomida bo'lib o'tadigan 12 ta sessiya ma'ruzachilariga omad va tinglovchilarga foydali muhokamalar tilab qolaman. So'zimning yakunida buyuk ajdodimiz Alloma Muhammad al-Xorazmiyning quyidagi so'zlarini keltirmoqchiman. Tarbiya mevasi katta aql, bilim mevasi yaxshi amal. Ushbu so'zlar bugun ham o'z ahamiyatini yo'qotmagan. Har qanday taraqqiyot va innovatsiyaning asosi bilim, tafakkur va uni hayotga tatbiq etishdadir. Sizlarga sog'lik, salomatlik va omad tilayman. E'tiborlaringiz uchun katta rahmat.
Rahmat, Akbar Jo'raboyevich. Hurmatli mehmonlar, forum ishtirokchilarini kirish so'zi bilan qutlash uchun sahnaga Birlashgan Millatlar Tashkiloti Taraqqiyot dasturining O'zbekistondagi doimiy vakili Akiko Fuji xonim taklif etiladi.
Good morning, Your Excellency, Mr. Tashkent, esteemed guests and colleagues. Very good morning. Assalamu alaikum. On behalf of UNDP, I am very grateful and honored to be here to speak at this conference. Artificial intelligence, AI, is racing ahead at lightning speed. Yet, as AI surges forward, human development stalls. This is what UNDP Administrator spoke at the launch of UNDP Human Development Report 2025, launched earlier this month. And since 1990, UNDP has issued Human Development Reports exploring different themes of the time. And it is not a coincidence that this year's legal forum has also chosen the same subject, the age of digital technologies. Just like other parts of the world, Uzbekistan is also taking active steps in introducing digital technologies to improve people's lives. Public administration, citizen service, and governance efficiency are the few examples, and these include digitalization of public services and AI-based services to answer citizens' queries. Uzbekistan has also adopted a strategy for the development of artificial intelligence technologies until 2030, aiming to elevate AI-driven services to a 1.5 billion industry. This strategy underscores the country's commitment to integrating AI and the digital technology across sectors such as finance, health, agriculture, energy, education, everything, you name it. And ethical standards and data transparency are important elements. And what is more important is, in line with these strategic objectives, Uzbekistan's legislative chamber passed the Regulating Use of Artificial Intelligence Bill earlier this year in April. The legislation aims to define AI within the legal framework, establish state policies for its application and delineate the responsibilities of a designated regulatory authority. And key provisions include mandatory labeling of AI-generated content, prohibitions against AI applications that infringe upon human rights, and restriction on decisions solely based on AI output, particularly in context affecting individual freedoms and dignity. These initiatives illustrate how Uzbekistan is leveraging digital transformation towards effective governance reform, and the reforms have also resulted in enhancing Uzbekistan's ranking in Global E-Governance Development Index from 87th in 2022 to 63rd in 2024. While these positive examples are achievements, already in place, legal framework for the wide use of digital technologies, particularly AI, is still under development. The UNDP Human Development Report, which I mentioned earlier, reminds us it is people, not machines, who determine which technologies thrive and how they are used and whom they serve. And therefore, central to this year's legal forum, in my view, is the question of how we view the role of people in an AI-driven world. And the legal frameworks will play a vital role in helping us to make important decisions. And UNDP Uzbekistan stands ready to support the government of Uzbekistan in this journey. Our ongoing support includes enhancing the legal framework on usage of AI as well as legislation, strengthening the personal data protection laws and regulations, introducing legal framework on the public data management system, and utilizing the UN data governance framework to research the AI implementation. Once again, I would like to thank the organizer for bringing all of us together here today, and I look forward to a fruitful dialogue and discussion. Katta rahmat.
Rahmat, Akiko Fuji xodim. Hurmatli mehmonlar, forum ishtirokchilari, forum uchun tayyorlangan video rolikni tomosha qilish uchun hamma o'z diqqatini ekranga qaratishini iltimos qilamiz.
Algoritmlar, Al-Xorazmiyning fikrlari insoniyatni yangi dunyo sari boshlagan ilk kodlar edi. Raqamlar endi qog'ozlardan qudratli mashinalarga ko'chdi. Inson hayoti raqamlar ichida qayta shakllandi. Bizning huquqimiz axborotdan to'g'ri foydalanish. Inson aqli yaratgan texnologiya endi o'z qo'li bilan bizning zamonimizni boshqarmoqda. Kelajak zamonaviy texnologiyalarning asri. Ammo u bilan birga keladigan muammolarni ham unutmasligimiz kerak.
Avtopilotda odam urib ketdi. Bunga kim javobgar?
Sun'iy intellekt asosida sudya noto'g'ri qaror chiqardi va
sun'iy intellekt yozgan ssenariyning muallifi avtomatlashtirilgan tizimdagi hisoblash xatosi tufayli 700 dan ortiq pochta xodimlari asossiz ravishda jinoiy javobgarlikka tortilgan. Bu xatolikni sudda isbotlash esa yillarga cho'zildi. Sun'iy intellekt ayrim bemorlarga noto'g'ri yoki hatto xavfli davolash usullarini tavsiya qilgan. Tizim bemor haqidagi ma'lumotlarni to'liq o'rganmay tavsiya bergan. Natijada bemorning hayoti og'irlashib qolgan.
Fikrlash qobiliyatining yo'qolib borishi, sun'iy intellektga shaxsiy hayotni ishonish, haqiqat va yolg'onning chegarasi yo'qolishi. Yangi dunyo, yangi qarashlar va yangi mas'uliyat. Raqamli sivilizatsiyaga huquqiy missiya kerak. Hayotimizni tubdan o'zgartirayotgan texnologiyalar yangi huquqiy yondashuvlarni talab etmoqda. Dunyo yuristlari ushbu murakkab masalalarga adolatli yechim izlash uchun muhokama maydonida jam bo'ldi. Raqamli texnologiyalar davri. Kelajakni huquq va adolat asosida yaratamiz.
Good morning, and welcome to Tashkent Law Spring. What an exciting time. We've never seen such transformation in our lives before. And you're here in Tashkent, Uzbekistan to hear some great discussions. We have amazing panelists that are going to be coming up. And we're going to be discussing what is the right legislation and regulations to put in place so that we can make sure there's a balance with innovation. What do we do in terms of the digital transformation that AI is bringing? And then finally, we'll look at cybersecurity and how do we sustain this transformation. We're going to have a great time today, and thanks for being here. Now let me bring up our panelists. We have 6 great panelists coming up here, and the first one I want to introduce is Her Excellency Miriam bint Ahmed Al Hamadi. Please come up on this side. Our next panelist that's coming up with us is Her Excellency Aslana Othman Saeed. I'm delighted to introduce Mr. Shirzad Shermatov. And now we have Pablo Fuentes Nettle. Next is Tatiana Teplova. And finally, to round out our panel is Mark Lewis. And to start off our speeches is Her Excellency Al Hamadi. Please, Your Excellency.
Your Excellency, esteemed guests, Assalamu alaikum wa rahmatullahi wa barakatuh. It's an honor for me to be here with you in this forum to present the UAE outlook for the future of the legislations. I'm sorry there, can I have the clicker? Yeah, the clickers. Thank you. Which is driven by the ambitious vision of our leader, His Highness Sheikh Mohammed bin Zayed, the President of the UAE, which is centered around the sustainable development, prosperity, and achievements. And also it's under the direction of His Excellence Sheikh Mohammed bin Rashid, the Vice President, Prime Minister of the UAE, ruler of Dubai, which is also focused on how we can make our legislation robust and proactive for the sustaining the economy, and the same thing for the empowering our society. As you know, that UAE is a federal government which has 7 local emirates, and our constitutions give the authority for the federal law that it should be applicable to all the emirates. But at the same time, the local governments also have the provisions to issue also their law that satisfy their needs, but at the same time should not be conflict with the federal law. Our constitutions also, how we can implement our constitutions is by issuing law, or sometimes we are issuing decrees of law whenever our parliament is on leave, or at the same times if we have any law which is very urgent. We have also cabinet resolutions, we have ministerial resolutions to ensure that law is being implemented in the UAE. Our legislative model, as you know, everyone in the most of the countries is different. Sometimes you feel that the legislative model is centered with the government itself, like the cabinet or the general secretariat or the presidential office. Sometimes the legislative model, it is with the Ministry of Justice. In the UAE, we have the model that managing all the legislations in the UAE is under the General Secretariat of the Cabinet. So we are leading in the General Secretariat the process of preparing, reviewing, and updating all the federal legislations. We are taking the measures to issue the federal legislations. We are overseeing the implementation and the impact of the federal legislations in coordination with all our stakeholders and the local government. We are also monitoring the global trends and coordinating with the ministers to ensure that the law are always robust and updated on time. And also, we are managing the UAE legislative platform, which I'm going to explain it later on in this session. However, our Ministry of Justice is one of our main stakeholder in the legislative model. However, they are responsible for preparing all the federal judiciary and federal public prosecution. They are heading the Federal Judicial Council. They are also regulating and licensing anything related to lawyers, law firms, private notaries, and translators and translations offices. We ensure in the UAE that there is a quality and quality standards of our legislations. We ensure that any law that is issued in the UAE is agile, proactive, it is evidence-based, advanced technology tools is being adopted. We are ensuring that in our legislations, we are promoting trust, ensuring justice, equality, rights protection, and equal opportunities for anyone is living in the UAE. Maybe at the last, there was a direction from our leaders that we need to update all the federal laws. So this was a big transformation has been done last 4 years. Now we have in the UAE more than 85% of our legislations have been updated up to date. We don't have anything which is old style or old laws in the UAE. We have rebuilt many of the laws because it was not suitable for the current situation, but it was suitable in the past. We have also issued more than 40 new law in the UAE. Actually, what we have achieved in these 4 years is double what we have achieved in the last 10 years. Also, we have in the UAE to ensure the transparency and to facilitate the easy access to any law that is being issued in the UAE. We have launched in 2024 the UAE legislations platform, and this platform The advantage of it, it is very interactive. It's a comprehensive platform that all the legislation of the UAE, you can access to it. It is in Arabic and English. It allows, you can get a copy of any legislations in the UAE in any format you want. It also you can access it through your mobile. It's linked to the official gazette of all the 7 Emirates. It's tracking. You can go to the platform, and if you see any law, you can track all the amendments that is happening to the law. It has an advanced searching engine and AI assistant that facilitate navigating and understanding the federal law and regulations. Now, we also, in this platform, what we are doing, we are introducing public engagement. We need all the laws before we issue it, before we amend it. It goes to all our investors and the private sector. So we engage them with us to update any law and to give us comments. What is this law? What is the problem of this law? What is the challenges we have in this law? So we are through the platform. And we have also the business segments. So any law we have it, we target any business group, for example, lawyers, investors, SMEs, entrepreneur. The law itself, it goes to them directly. We get their feedback, and accordingly, we update our laws. Also, to ensure that our law is in implementation, the cabinet have approved KPI and other tools to ensure the law is in implementation. And we monitor all the laws that is being issued in the UAE, and we make a ranking between all the ministers, and we show it in the cabinet, which of the law is being delayed and why it's being delayed in front of the cabinet. I will give you some of the examples of the significant legislations that is driven by the technology. We issued the first e-commerce law to regulate all aspects of doing business digitally. We issued the first federal legislations that are regulating the virtual assets and cryptocurrency. We tightened the penalties of cyber crimes that threaten the privacy and security of the society. We reduced the legal age of doing business from 21 to 18 years to allow young talents to establish their startups at early stage. We enabled 100% of foreign ownership of commercial companies. We have revamped our visa and residency system, and we introduced many types, such as the golden visa. We have expanded the scope of our intellectual property law to introduce new areas to protect technology innovations. We amended our judicial laws. For the first time, we allowed electronic evidence as a means of proof. We have also introduced one judge to consider the initial lawsuits instead of 3 judges, which has tripled the number of processed cases in the court. We reduced the time of issue judgment from 100 days to 80 and appeals from 60 to 30 days. We introduced a specialized court for the specialized dispute and permitted the use of English language in this court. Also, our Ministry of Justice did also revamp of its services. Major project was done to ensure the integrated of digital services, for example, digital case management, remote hearings, voice recognition to write court proceeding instantly, streamlined the services with the 3-step customer journey. They have also introduced AI in their services, AI platform for all judicial principles and procedures, AI system to monitor the time, quality of judicial service and legal consultations, smart courtrooms equipped with virtual judge and digital expert, and also they are linked to the big data to facilitate more, fast analysis. Also, we have in the UAE something called Regulation Lab, which is under the General Secretariat of the Cabinet. And this lab is actually a platform that give secure and innovative environment to test emerging technologies and enable the UAE to be the forefront of the future-ready nation. The Regulation Lab, it's actual, bring all the regulators with the private sector, innovator, business leaders to participate in developing legislation for the emerging technology. Any technologies, any emerging technologies that there is no law for it, actually we bring it to the Reg Lab. It's one of the sandboxes but it is under the government. We give temporary license for that technology. We bring all the stakeholders. We limit the zone of implementation, and according to the results, we draft the law that is required. Sometimes the experimentation takes 1 year, sometimes it takes 2 years before we introduce that technology and put the law for it. We are ensuring that whenever we regulate any new technology, we always think, is it the right time? Is it early? Or we should not regulate it at this time? And that's why all our efforts has been also raise our ranking in many of the international reports, as it's being seen in the screen. We have also working with the World Economic Forum on a new project called the GRIP, which is Global Regulatory Innovation Platform, which is started, we signed with them in Davos in January 2025. The aim of this platform, that we are going to develop the Future Readiness Index, an indicator that measures the maturity, agility, effectiveness, and impact of the regulations in the UAE, and it will be open for all the countries to make self-assessment to it and to see their ranking. And we are going also to develop a global playbook that guides policymakers and offers strategies, best practice, and actionable recommendations. Same thing. All this accomplishment of the legislative transformations was the baseline for us for the next era, which is we are introducing regulatory intelligence to leverage the power of the AI in our regulatory framework. As all of you know that legislation in the intelligent age, that 50% of the legislative process in the developed countries are integrated with the AI. 40% of the time is being reduced in preparing legislative texts with AI tools. 25% we can have faster legislations. 30% of the legislative bodies are expected to use AI in the coming years. And that's why, and also, as all of you know that in the UAE we are moving very fast in the AI adoption, and we have introduced a new first Stargate outside the US, okay? And also the Stargate will provide the best-in-class infrastructure to deliver AI that will meet the demands and of the intelligent world. Also, there is many efforts has been raised, the ranking of the UAE in the AI. And also, finally, we have also a new project have been introduced in April 2025. This one is actually related to the AI in legislations. It is now, if you go to the ChatGPT, if you search for any latest legislations, you can find it. If you want the AI to help you to draft any law, it can help you. If you can make comparison between the law and to see the gaps, ChatGPT also can help you. However, we are working on this one and further.
Excellency?
The Cabinet, yes.
Your Excellency?
Yes.
I appreciate this very, very much. I want to bring us to the close because we have a point here. So if you don't mind, is this your final slide?
Yes.
Okay, please, go ahead.
Thank you. So that's why we have introduced the first integrated regulatory intelligence framework, and we have introduced the first regulatory intelligence office, under the cabinet. And the aim of that framework, that we need to have real-time monitoring of the global developments, so we can introduce it in our legislations. We need in-depth analysis of the legal text. We need also to propose legislative amendments driven by data in a global best practice. We have advanced tools. We will introduce advanced tools for faster and more agile drafting of our laws. Actually, our legislations will be also linked to the social media, so any comments that will come on our legislation, it will pop up to us and will tell us that we need to update our legislations. So it is much more interactive AI system that links with the government and our investors and our private sector, so we can have agile, prompt, instant development of our legislation. And sorry for taking more time. Thank you.
Thank you, Excellency. I certainly took away a few points myself here. First of all, what gets measured gets improved. So Her Excellency certainly shared a lot of data points with us of what's going on. And also, it's not just a change at the legal level, they've gone to the Constitution. One thing that stuck out for me was 85% of laws are changing. Now let's go ahead to the Malaysia side of things. And I'm so glad to be able to introduce Her Excellency Azlana Othman Saeed, as she shares a bit about creating a safer digital future in terms of online child protection. And a question I had for her was, what will it be like implementing digital law? Is it an uphill battle? And then how do you conquer that battle?
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I think I answered your question, Keith, after my slide.
Yes, you may.
Okay. First of all, distinguished guests, excellencies, ministers, participants, thank you so much for inviting me to represent the government of Malaysia to the government of Republic of Uzbekistan and Ministry of Justice for bringing us together as guardians of humanity, most precious asset, which is our children. In a world increasingly shaped by digital innovation, we face an undeniable truth that the same technology that empowers can also endanger. It is something that the world must understand, that the internet or the AI is part of the everyday life of our children, and they are exposed to risks, which, for example, issues of cyberbullying, exploitation, and inappropriate content. These dangers can have devastating effects on the mental health of children, safety and development, and we as a government must act urgently to educate, to protect, and to hold platforms accountable so that the digital world becomes a safer place for every child to learn, to grow, and to connect. I'm very honored to be given this opportunity, and I would like to explain to the members of the participants of the audience here in reference to Malaysia's approach to the digital threat to our children. Ladies and gentlemen, let me briefly inform the participants on the existence of a law that we have created in 2024, which is called the Online Safety Act. Before this law was formed, the commitment of the Malaysian government to protect children created way back in 2017, when I was the Minister of Law then, and we had a law that was called the Sexual Offences Against Children Act for 2017, or Act 792. Right. This particular act that we created was to foresee challenges or threats to our children in reference to child grooming, sexual communication with children, child sexual abuse materials, marking a watershed in Malaysia's legal landscape. The reason for the existence of this particular law in 2017 was this man called Richard Huckle, a British gentleman who uses his platform to take advantage of the children in Malaysia and taking advantage of the lack of the laws that we had then. Richard Huckle, a British national, portrayed himself as a devout Christian and as a teacher, embedded himself within unprivileged children, communities in Malaysia, working on humanitarian platform, working on education platform, but systematically abused dozens of Malaysian children, exploiting poverty trust and the absence of the existing law then in 2017 or before 2017. To detect, to prevent or even to prosecute such crime. So what happened in 2017 was this man who abused a lot of children in Malaysia. So we created this particular law. Now, if what Richard Huckle did in 2024, and we do not have this law which we created last year called the online harms, Malaysia would still be in an uphill challenge to face the challenges of such exploitation, especially in the digital world. In reference to Richard Huckle's case, we also added the fact that this is the element of trust, the element whereby when you look into the act, the mandatory reporting, we also look into the existence of our commitment to shared responsibility in safeguarding children. The Sexual Offences Act against Children that we put in 2017 was very painful, but it was a necessary turning point. And since its existence, we continued to strengthen the law to address the real-world challenges. We also amended laws on Criminal Procedure Code, Evidence Act, and Evidence of Child Witness. Now, this is all in reference to mostly perpetrators that we can identify based on the law of 2017. With the challenges of technology, you must also understand when it comes to children, harm is harm, whether it takes place in a room, person to person, or through a screen. And when you speak about digital harm, the perpetrators are not in physical presence of the vulnerables. The perpetrators are on screen. The perpetrators are in their phone. The perpetrators are in their desktop, in their laptop. So basically the challenges then that faced with the government is that how do you make accountability for such challenges? So the features that we have on the online harms is number one, accountability of platform providers, proactive monitoring of content of harmful to children and labeling of AI-generated content. Yet as we address new threats emerge in the digital world, and Malaysia took a bold and necessary step with the creation of the Online Safety Act. We feel that this is a moral declaration, not just a normal legislature, but we want the platform providers, those who perform or those who allow the platform to be utilized, to be accountable. And the Act itself we created was a statutory duty of care imposed on online service providers. In reference of that, if you can see from the screen, the 12.5% of children globally affected, subject to online harms. And as you can see, just as important that the Act requires transparent labeling of AI-generated content, in an age of deepfakes and digital deception, our young people deserve to know what is real and what is artificially created. By codifying these duties, we aim to foster a digital environment rooted in accountability, transparency, and trust. Our law is deliberately victim-centric, ensuring that protection, regress, and dignity are prioritized regardless the mode of abuse, digital or otherwise. Recognizing the pace of technological change, Malaysia, in reviewing the Sexual Offences Act against Children, which is the 2017 Act, to criminalize AI-generated sexual content involving children and to strengthen the cross-border applicability. These efforts respond not only to new digital threats, but also to the alarming rise of children and adolescent suicide linked to cyberbullying and online exploitation. To address this, we have introduced and enhanced cyberbullying provisions to clearer define and stronger enforcement tools. And our legislative journey remains dynamic, grounded in the real-world challenges, and committed to safeguarding children. Ladies and gentlemen, the Online Safety Act is not just an isolated effort. It is a part of a whole government digital trust strategy coordinated between multiple ministries and agencies. With the support of the Ministry of Justice, you can see the roadmap to My Digital Justice. Not just having a good law in reference to technological challenge is to get the whole ministry, not only the law ministry, but also other relevant ministries such as communication ministries, digital ministries, on the roadmap of My Digital Justice for a strategic framework. We embrace innovation, but never at the expense of human rights. Our laws serve as the guardrails that ensure technology serves justice, not just injustice. Laws alone are not enough, ladies and gentlemen. To be effective, they must be supported by strong implementation. And to answer the question by Keith earlier today to me is in reference to how do you make sure the laws that you create can be implemented. Now, in reference to the digital challenges, the platform of the technological challenge is a new platform for most law, for example, in reference to the court, in reference to the prosecutors and also defense. The common law system in Malaysia, as compared to some other civil law system, the element of
the burden of proof in reference to any criminal cases is a very high burden. And the biggest challenge for technological cases is to prove the perpetrators are not in the room, the perpetrators are outside from the room. So the elements of actus reus and mens rea and the high burden of proof is a big challenge for digital cases. So in reference to the question by the moderator to me earlier today, my immediate response is training must be done to the courts and also to the prosecutors. We must also train the system to understand the challenges of the digital in reference to the burden of proof. In lieu of that, one of the biggest challenges that we face is having the public to be aware. In Malaysia recently, there was a boy who uses the visual of a classmate, 16 years old, and it was a deep fake on AI. Now, in normal circumstances, it's very difficult to prove that he is the perpetrator because physically he did not touch the victim. But with the laws that we had in 2024 and also 2017, we combined both laws to prosecute. And because of the deep fake, we are able to arrest and charge this young boy in reference to using the AI-generated visuals. So these are the future challenges that we'll be facing and more challenges with the digital world. I would also like to inform to the general public or to the general audience, since my time is up, is that justice in the digital age demands not only good laws, but also those who are prepared to enforce such laws. Malaysia stands ready, not just to lead, but to learn. The Online Safety Act reflects our deep belief that every child deserves a digital world that protects their innocence, preserves their dignity, and nurture their potential. And I would like to end my speech today by informing all of us that we are responsible because the future of our children is our duty. Thank you so much. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Well said, Her Excellency Othman Saeed. And as I look around this room, all of us here have a responsibility for this next generation, how AI is going to be used or impact them negatively. And with that, let's move on to Mr. Shahzad Surmatov, who will be bringing us through the digital transformation developments and AI in Uzbekistan. Mr. Surmatov.
Thank you very much. Assalamu alaikum. Good morning. Dear guests, I'm very much honored to be here sitting with such high-level panelists. And of course, in Uzbekistan, we have been observing huge transformation in all areas thanks to the long-term visionary leadership of our President, His Excellency President Mirziyoyev. If you just imagine 8 years before Uzbekistan, it was quite closed country. You couldn't imagine so many people coming and celebrating such international events in Uzbekistan. Even we didn't have just a currency convertibility or opening of the borders with our neighbors or things like this. So there was a huge and very fast transformation at all levels of our country. And of course, digital transformation was part of that. And our mission of our ministry is to improve our people's lives through digitization, as well as to create them additional opportunities to find income. And from the second part of our mission, I would like to inform that Uzbekistan is working on making sure that we are becoming a very attractive place for all IT companies to open their offices here. Because if you look back to the breakup of Soviet Union, since that time, we have grown plus 16 million people, whereas other big countries, they had a decline of population. So our main mission is to find the good opportunities for highly paid jobs for our people. So instead of sending people to work abroad, we rather try to bring those remote jobs to Uzbekistan. So if you have an IT company or IT-enabled services providing company, you have a very good taxation regime in Uzbekistan, and we have extended this to up to 2040. So when we started in 2017, we had less than 10 companies with foreign capital working as IT park residents, but now every month we see more than 30 new companies opening their offices in Uzbekistan. And therefore, taking this opportunity, I would like to invite you all to also consider this opportunity, because if you provide the legal services from Uzbekistan, you can save a lot of costs from the taxation, from the affordable talents and low cost of doing things from Uzbekistan. So we can discuss this opportunity after also to help you to open up your presence in Uzbekistan as an IT-enabled services outsourcing company. And the second component of our mission is to improve people's lives. Here we are working as one team with our Ministry of Justice, and I would like to express our gratitude for the Minister of Justice for all the support and overall for organizing this important event, because back in 2017, before that, it was very difficult to get the government service. For a citizen, for a business, you had to go to the several agencies to get the service, or unfortunately, you had to bribe someone to get the license, etc. But for the past several years, thanks to this political will of our president and synergy between our ministries, now you don't have to go to any office to get the public service. You can get most of all your services through your mobile phone. And our aim is to make sure that more and more people will be having proactive services without even necessity of applying to service, but rather the e-government services are provided upon the required time. And also, we do not want to have the monopoly on the e-government services to only government portal. We are working with all the banking service companies, with the financial system companies. So now banking applications and the financial applications, they can provide the government services as well, which is increasing access to the government services, and because they know their clients better than the government, and they have the much better user interface, they have much better user experience, especially so. They are now also benefiting from these applications. Here you can see that so many banks and the payment companies have already implemented such systems. And thanks to this, for the past two rankings, Uzbekistan was faster in implementing in e-government than 24 other countries, meaning that we have increased in global e-government ranking by 24 positions. And we have set very ambitious goal to be in top 30 in this ranking by 2030. Of course, it's very difficult. It's very ambitious task, because if you look currently into these top 30 countries, these are very rich countries in terms of GDP per capita. But I hope that if we can work together with all the relevant government officials, we can definitely make sure that we will be in that target. And taking this opportunity, I would like to also invite you all to participate in the upcoming UN Public Service Forum, which is going to be held in Samarkand coming June 23rd, 26th. It's going to be also a very important event, which is organized by UNDP, which is actually responsible for organizing this kind of rankings. And we started with the outsourcing. Now we are also promoting the startups, because we have so many young creative talents. Uzbekistan was historically the center of Great Silk Road, where we had a mixture of different nationalities, different cultures, different religions. So here we have a very fruitful ground for innovative ideas and young talents. And now we are creating the necessary ecosystem for those talents to grow as successful startups. And there are many new startups, and we invite all other startup ecosystem participants also to look for these opportunities to Uzbekistan and to come work with our startups. And when it comes to the AI, we have implemented our AI development strategy. Here also the focus on the welfare of the people. So it's not AI for the sake of AI, it's AI for the benefit of people. So all those projects which we are implementing according to our strategy should eventually benefit our people. And the difference between Uzbekistan and the developed countries is that, as I said, our priority is to find the highly paid job opportunities for our young people, whereas in most of the developed countries, you see the demographic trends. There are not so many new babies born, and they have their different challenges. So here we try to make sure that we focus more on improving the capacity of our young people and trying to make sure that AI is creating the new job opportunities. And for the past ranking, we have improved plus 17 positions in Global Government AI Readiness Index by Oxford Insights, and I hope that by 2030 we will have additional $1.5 billion of experts from AI-related products. And of course, time is limited, so already it's showing that time is up, so I would like to conclude as fast as possible. We are trying to work with our legal team, with our Minister of Justice and other stakeholders to implement several projects in that area as well. But as it was mentioned earlier in the opening session and with our high-level panelists, not everything is kind of good, and not everything is opening up the opportunities. There are many challenges also created by the digitization and the access to information. So our aim was to provide the access to internet, high speed and the low cost internet, that more and more young people will be learning new foreign languages or new skills. But if you analyze the current usage of internet content, unfortunately, most of them are using for useless things like the entertainment or porn or something else. So if eventual result is not always as we intend to have. So we are very much interested in working together with all your international partners on making sure that all the access to information, all the access to IT, AI is really doing good or not and doing harm to our young people. And we would like to be able to make sure that it's really human-centric and it's really benefiting the well-being of our people. Thank you all.
Thank you so much, Mr. Shermatov. Again, very interesting as we've moved from Her Excellency Al-Hamadi down to Mr. Shermatov here talking about technology going across all industries, and I love the competitive posture that you've enabled Uzbekistan companies to achieve. So well done. Now we go over to Pablo Fuentes Neto, and he's from Oxford. He's going to be taking and sharing some of us how can states introduce AI tools into their governance systems. Mr. Neto, please.
Thank you so much. Well, first of all, I want to thank the government of Uzbekistan and particularly the Ministry of Justice for this kind invitation. And it's a true honor to be sharing panel with people making a real impact. And it's also great to see the enthusiasm around digital technologies and AI in Uzbekistan. So first, let me introduce myself. I'm Pablo Fuentes Netel. I work for Oxford Insights. We are a research center and advisory organization based in the UK, but working internationally to advise public sector organizations on how to make technology work for the public good. So today I will be providing some insights from our work supporting governments in their AI journeys, and particularly I'll talk to you about the Government AI Readiness Index, which is one of our flagship reports. I'll share some of our findings, and also I'll just go very briefly through what we found in 2024. So AI is everywhere, and AI is moving at an unprecedented pace. So in recent years, the adoption costs of AI have dropped dramatically, making AI more accessible. The global AI market is projected to reach $244 billion in 2025. Tools like ChatGPT have become part of the daily lives of hundreds of millions of users globally. And this is, of course, having impacts in various aspects of life, including labor markets, citizens' demands, etc. So, and we think that governments should embrace this transformation. As we just heard from the minister, there's a lot of really interesting use cases or applications of AI to improve public service delivery, to enhance back-end government operations, and also to facilitate evidence-based policymaking. and therefore, this is something governments should really care about. And of course, this is not an easy job, it's not an easy journey, and we at Oxford Insights support governments in this mission by supporting them across different areas. For instance, unlocking data for AI readiness. We've developed roadmaps together with the Global Partnership on AI to help governments share data with AI developers in a responsible and effective way. We've supported AI strategy work and the development of governance frameworks globally, and also enabled the implementation of policy solutions such as data sharing mechanisms. And through our engagement with governments, we've noticed that there's increased enthusiasm and interest about artificial intelligence, but at the same time, we've also witnessed that there's often a lack of understanding of what foundations are needed for a government to be in a good position to integrate AI into public sector operations and service delivery, and how to foster a responsible AI innovation. So with that in mind is that every year we release the Government AI Readiness Index. So this report has the intention of providing a valuable benchmark tool for policymakers and researchers around the world, and also to serve as a resource to map key trends and developments in the field of AI policy and foster collaboration and knowledge sharing amongst peers. So the index is based on the exam question of how ready governments are to integrate AI into public service delivery, and based on these questions, we assess around 190 countries. So we started in 2017, only measuring OECD member countries, and now we're very happy to measure almost all UN members, and also happy to see that the Government AI Readiness Index is now a trusted tool for policymakers, being referenced in 26 national AI strategies globally. So how do we measure AI readiness? Well, our framework is based on three main pillars: government, technology sector, and data and infrastructure. The first one is focused on the governance, regulatory framework, and also the digital capacity of the government. The second one is focused on exploring how mature and how innovative technology sectors are in a particular country. So governments need an innovative pool of providers. And their last pillar is data and infrastructure, which is focused on the enablers data, which is it's critical for AI innovation, and also we focus on the foundational infrastructure that allows governments to make sure that AI is not benefiting just certain sectors of the population, but the benefits are well distributed across the population. So what did we find in our last edition, which was released in December 2024? We saw that, well, globally, AI strategies are on the rise. So we saw 12 new AI strategies published or announced in 2024. This is 3 times more than 2023. We see growing diversity in terms of the strategies that have been launched, they especially come from low and lower middle income economies. We also see diversity in terms of geographic spread, with strategies emerging from regions such as Sub-Saharan Africa, South and Central Asia, and Latin America. We also see that right at the top, there's some interesting developments. Even though the US leads, it's important noting that its advantage is heavily determined by their technology sector. So if we analyze the 3 pillars, we see that the US outperforms the world primarily due to the maturity and scale of their tech sector, but we see countries such as Singapore and South Korea making significant strides right at the top, and leading pillars such as government and data and infrastructure. Now, we also see middle-income economies closing the gap and making significant strides towards breaking the top 50. So countries such as Ukraine, Costa Rica, and Uzbekistan are getting the basics right. What we mean by this is they are investing in foundational governance, such as developing national AI strategies, adopting AI ethics principles, and strengthening data governance. And finally, just a glimpse and a very, very brief overview of what we found in South and Central Asia. We divide the world in 9 regions, by the way. One of them is South and Central Asia. In this region, we see that India, Turkey, Uzbekistan, and Kazakhstan are leading the region, and all of which are scoring above the global average. There's disparity in the region, and also there's disparity within sub-regions such as Central Asia and South Asia. But we see that when we look at it from the pillar perspective, we see that the government pillar is relative strength for the region. The region presents solid governance foundations, with nearly half of the countries had presented or developing a national AI strategy. And we also see that the region's most pressing gap lies in the data and infrastructure pillar. So just to close, final remarks, in order to advance AI readiness in the region, it's critical that governments prioritize strengthening foundational enablers, particularly data availability, accessibility, and supporting infrastructure. But of course, it's worth noting that there's no one-size-fits-all solution. So every country has its particularities, different needs. And exactly the purpose of the index is to show that there's different ways to get to the point where countries are more AI ready. And in that sense, also international and regional collaboration are key to learn about each other's journeys, exchange experiences, and also harmonize governance. So these kind of forums are very much welcome. So this is everything, and thank you so much.
Thank you, Pablo. And can I just repeat what you just said about collaboration? You'd love for these folks to come and share and their stories and the impact and so forth that they're having. Is that right?
Yes.
Okay, wonderful. Thank you so much. That's exciting for us. You're not alone on this journey, which I think is really important. We're all growing and learning together. And with that, let's move on to our next speaker here, Tatiana Teplova. And I'd love to be able to hear some of the things that are going on in the digital transformation that are within your scope. So please, Ms. Teplova.
Assalamu alaikum. Good morning. Dear ministers, excellencies, colleagues, first I'd like to thank the government of Uzbekistan, the Ministry of Justice, for inviting OECD to join this important conversation. And we are here today indeed because the world is changing and fast, and justice systems must change with it. More people than ever need help in resolving their everyday justice problems, be that family, be that debt, housing, employment, or small business disputes. Yet, too far often, they face a justice system that is distant, out of reach, and slow. At the same time, we see, and as we have heard from our distinguished panelists before me, digital technologies, including artificial intelligence, are transforming every corner of public service. And justice cannot be the exception. In fact, it must become a front runner. The choice is simple. We either build justice systems around the needs of people, or we fall further behind. Let us start with the basics. Digital transformation is not about moving a paper online. It's about delivering justice that is timely, intuitive, and inclusive. When digital technologies are used to rethink, improve, and simplify the delivery of services, they can help improve access to justice and meet people where they are. When data is used intelligently, it tells us what is working and what is not. It tells us who is falling through the cracks. Take Portugal. Through the Justicia Plus program, they are combining digital platforms, service delivery and mapping, legal needs surveys, and AI-driven innovation, all rooted in a people-first approach. That is exactly what we need more of. Across OECD countries, we are also seeing a strong momentum for online dispute resolution. And our new OECD framework on ODR, on online dispute resolution, lays out the principles: accessibility, fairness, transparency, and trust. When done right, ODR is not just a tech upgrade. It is a lifeline for people with no other path to resolution. And then there is AI. And let's be honest, it is changing the game. AI can help triage cases, summarize legal texts, flag procedural risks, and even predict where bottlenecks will hit next. It can make legal systems smarter, faster, and more proactive. But it's not magic, and it's definitely not neutral. If the data behind AI is biased, the outcomes will be too. If algorithms operate in black boxes, fairness disappears. If AI is used without oversight, rights are at risk. This is why at the OECD we will soon be releasing Governing with AI, our flagship report guiding trustworthy and effective use of AI in public governance, including justice. It brings together real-world examples showing how to get AI right, with guardrails, transparency, and public value front and center. AI can be an accelerator or a justice divider. What makes a difference is how we govern it. Here's what we need. First of all is strategy. Digital justice and AI must be driven by a whole-of-government strategy that links technology and data to access to justice, not just tech in a vacuum. Next is data infrastructure. Many justice systems still rely on paper files or fragmented digital systems. Data must be collected, interoperable, and governed ethically to allow a data-driven justice and leverage the use of emerging technologies, including AI. Third is skills and leadership. Because transformation doesn't come from a code, it comes from vision. Judges, ministers, civil society, innovators working together. Judges, clerks, legal professionals must be equipped to use and scrutinize AI tools. And finally, trust, ethics, and inclusion. AI must be transparent, explainable, accountable, auditable. Human judgment cannot be outsourced. That is non-negotiable. And most importantly, people must stay at the center, not systems, not efficiency targets, not shiny dashboards, people. Colleagues, digital tools, data and AI, they are not mere innovations. They are instruments of justice if we use them right. Let's not wait for disruption to happen to us. Let's shape it with purpose, principles, and fierce commitment to inclusion. The OECD stands ready to support all countries through our tools such as the Access to Justice recommendation, our frameworks such as the framework on online dispute resolution and digital government, and our upcoming work on governing with AI. We have the tools, we have the data, we have the momentum. Let us build justice systems that not just work, but work for everyone. Rahmat, thank you.
I love that perspective. People first. People first. Thank you so much, Mr. Floba. Really helpful. And now as we go on to the last panelist here, Mark Lewis. He's going to be talking about strengthening the, and this is something that's so important these days, rule of law. So, Mr. Lewis, you have the floor.
Well, thank you very much. I would first like to thank the government of Uzbekistan for hosting this event. It's a great honor to be here and participate with these wonderful distinguished panelists, distinguished guests, and attendees. And I will be talking about how technology can advance the rule of law. And I'll first talk about the rule of law globally, and then link it to the current status of people's justice needs and legal needs. And this will link quite nicely with what Tatiana was just talking about. And then finally, we'll talk about the role of technology and how technology can help. And the aim will provide, like my other colleagues, fellow panelists, is to provide a bit more context for the discussions we'll all have today and tomorrow. Now, I'm from the World Justice Project. We're an independent organization that collects rule of law data and produces research, disseminates that research, and then works with selected countries that want to improve the rule of law. So we're very much about data and metrics and the rule of law. And a product that we're probably best known, another index, is the Rule of Law Index. And the Rule of Law Index is a survey we do every year of 142 countries on the basis of actual data and metrics about the quality of the rule of law in those countries. Now, most of my panelists have been very optimistic, Professor Carter. I'm going to be a little bit pessimistic, but we're going to come back to the optimism. So the pessimism is that for the 7th straight year, the rule of law has declined globally as measured by falling or weakening in more countries than it is improving. So we speak about a rule of law recession, and that's continued for the 7th straight year. Now it isn't all bad. There are some countries which have made quite considerable progress over this period of time since, in this case, we're measuring since 2016. Uzbekistan is one of the global leaders in terms of advances on the rule of law. This is a story many of the people here will understand very well. But globally, again, the story is a bit of a more somber one, where roughly 3/4 of the world's population live in countries where the rule of law is declining. Now, when we measure the rule of law, we actually break it down into 8 components or factors, and these include civil and criminal justice and anti-corruption, regulatory enforcement. And the story, when you break down the data, you get the same result, which is out of 7 of these 8 factors, you see globally a continued decline in the quality of the rule of law. In fact, the only one factor that's increased, again, globally, is order and security. And if you break it down a bit more, looking first at civil and then criminal justice, you still see the same story. Here, in this case, we're looking at civil justice, and it's the affordability, it's the accessibility, it's the independence, it's the effectiveness. And again, the story where you see globally a decline in the quality of civil justice. And if you look at criminal justice, you can see on the screen, it's a similar conclusion. All of which is to say, again, globally, is that the quality of justice systems, in terms of delivering outcomes for people, has continued to deteriorate globally. So this is some of the pessimistic news. Now, let me turn to justice needs and legal needs. So these are the people that have legal problems, right? So some work that the World Justice Project did a few years ago estimated that roughly 5 billion people, yes, 5 billion people have unmet or have a lack of access to justice. Now, this is a problem because legal problems are quite prevalent or quite common. That is to say that in almost half of the countries that we measured, at least 50% of the population experienced one legal problem over the last 2 years. So again, legal problems are quite prevalent. And to add to the challenge is that people run into obstacles in resolving their legal problems. And you can see on the screen, in terms of, for example, a lack of access to adequate information. At least 50% of the people surveyed didn't have access, appropriate assistance and representation. Now, and if you take it one step further, one feature of the challenges that people face is that when they run into legal problems, they often then incur additional legal problems. So they may have a civil case or some criminal case and then run into some problem in employment law or family law. And so you get this building up of legal problems, and it's not going to surprise you that this impacts the poor disproportionately or more so. And in fact, this is consistent with some of the comments from our colleague in the introductory remarks from the UNDP. In terms of this absence of access to justice becomes a poverty issue. So here we have real problems. It's, rule of law is declining. People have unmet justice needs. It's incredibly challenging to address those justice needs. And then it becomes a poverty issue. So this is where I become more optimistic. How can technology help? Justice technology, we can think about it in different ways. Here we have a definition on the screen, but basically it's about access, assistance, and agency in justice systems. And for us, this is a helpful way to look at it from a diagnostic perspective and to help is to think about people's justice journeys. That is, if I have a legal problem, what are the different stages I go through to address that legal problem? Because in doing so, that can tell us where is the system working, where it's not, and then how can technology help? And of course, we've talked already quite a bit in some of the work that's happening around the globe. We'll talk more over the next 2 days about different justice technologies, websites, some apps, chatbots, and of course, increasingly AI, artificial intelligence, all of which has the ability to bring efficiency, cost savings, ultimately greater access to justice. The one point I want to leave you with, and this is an and, it's not a but, it's an and this is consistent with what Tatiana was just talking about a few minutes ago, is that it's very important that the technology is mapped appropriately to the particular stage in the justice journey. That's going to depend on that particular stage. It's going to depend on the country context. It's going to depend on the local context. But if you can do that, technology has the capacity to be incredibly powerful to achieve better information and advice, assistance and representation, and ultimately adjudication and mediation. And with that power has the ability for people to address the legal needs that I spoke to and ultimately help materially and substantially advance the rule of law globally. One last note is that the World Justice Project, in partnership with the government of Korea and the World Bank, is developing an assessment tool to do just that, which is a diagnostic tool to help countries look at, in the justice journey, what's the appropriate technology so that it maps to the local conditions. With that, let me thank you very much, and back to you.
Well done. Mr. Lewis has certainly given us another KPI on some of the dashboards that need to be added in. I think that's a very nice one. What do you think, Pablo? You can turn on your microphone. Go ahead. Not to put anyone on the spot, but I'll put you on the spot. Go ahead.
No. I mean, I totally agree.
You totally agree?
Yeah.
All right.
I guess it's about how you see that, how you use them, right? So, of course, you need metrics to know whether things are going well or not. But you need to be very careful on how you treat the data, how you collect the data that is shown by these dashboards, make sure it actually reflects reality. But always with a caveat that every case is different. As I said in my presentation, every country has its particularities, and it's very, very important to keep people at the center of this and make sure that any policy, any framework that is developed around AI takes into account citizens' needs and the institutional and legal and political system of that particular country. So I would say, yes, they're kind of necessary to measure progress, but it's always important to complement that with more kind of people-centric insights.
Thank you very much, Pablo. As we wrap up the panel, I'd like to, everyone wants to hear from you all. So I'd love to give you just 30 seconds. Can you do this? 30 seconds of what would you like the audience to take away from what you've heard and from what you think are most important for them to take away from the panel discussion today. Who would like to go first? A quick 30 seconds. Okay, Her Excellency Al Hamadi, please go ahead.
Maybe the adoption of the AI in the regulations, it's something coming up and we have to adopt with it. So I think AI can help all the countries because it's linked to many of the big data. And we have noticed in the UAE that adoptions of the AI have helped in many perspectives, either it is educations or in legislations. But however, we are still monitoring and we are still understanding how AI can help us with the precautions.
Thank you so much, Your Excellency. Please, Athman Saeed, please.
Okay, thank you. I think I would say we have to walk the talk and talk the walk. You understand? I can't translate it to Uzbek language. Can you?
Go ahead. I didn't hear quite what you said. Say that again.
I said we have to walk the talk and talk the walk.
And we'll talk, that's right. Okay.
I think that people-centric approach should be the main message, should be delivered from here, because everybody's talking about fast development of artificial intelligence, but unfortunately the natural intelligence is not catching up. So
okay.
the people's development, the people-centric approach should be the main message.
Okay, thank you very much. Pablo.
I would say two things. First one, my presentation was only focused on opportunities, but I think it's really, really important not to overlook the fact that AI also comes with a lot of risks. And as Mark mentioned, this is a critical aspect, and we should not forget about it. And the second one is, again, collaboration. I think it's key, especially in these times where there's a lot of normative fragmentation, a lot of different institutions telling governments what they should do. I think it's really important to harmonize how we approach AI governance, because otherwise it's going to be really tricky.
Thank you. And Tatiana.
Maybe three key messages. First is technology and AI are powerful tools for transforming justice systems. Second, they must be used transparently and fairly. And the third point is that they need to be at the service of the people. Thank you.
Fantastic. Transparent and fairness. Key point. And Mr. Lewis.
And consistent with these points is that technology became useful for the institutions of the justice system, ministries of justice and court systems, et cetera. And it can also be useful for the users. This is the people-centered approach. And taken together, technology can be incredibly powerful, as we've been saying, in terms of advancing access to justice. You've seen that case in Uzbekistan, in fact. And that can be an example for many countries as well. So
thank you. Thank you. And now we have one more guest. We have a special guest here today. I believe the guest is going to be joining us shortly.
Greetings. Thank you for inviting me as your digital guest. It's been really amazing here so far. I'm excited to be here.
I'm glad you're here too. I have a question for you. May I go ahead and ask?
Please, go right ahead. I'm here to answer your questions about the forum.
So how can AI be used for the benefit and in the interest of humanity? And I want you to approach two angles first. First is, what should the global purpose be? And second, how can we establish good ethical and legal standards?
That is a very important question. To ensure AI benefits humanity, its global purpose must be clearly defined as serving humanity, not replacing it. Additionally, it is vital to establish ethical and legal frameworks that anticipate technological development, ensuring law keeps pace with code to prevent technology from dictating its own will.
Fantastic. Thanks for that answer. Now, there's two more points here. What should we do about international cooperation and also digital equality?
Building on that, strengthening international cooperation is crucial because AI transcends borders, necessitating transnational legal regulation and an international ethical and legal standard, much like climate agreements. Furthermore, we must ensure digital equality, extending access to AI's opportunities beyond tech giants to include developing countries, social institutions, and citizens.
Well, thank you so much for joining us on the panel, AI.
You are most welcome. It is a pleasure to be a digital guest at the Tashkent Law Spring Forum and share insights on these critical topics.
All right, let's give everyone a round of applause here. Thank you so much, panelists. Well done. All right. If you can go exit on this side here. Tatiana, real pleasure. Thank you. Thank you. Good. Oh, yeah, please, please. All right. The first panel was great. Thank you so much, panelists. The next panel we're going to be so very happy to bring up in just a moment here And man, we've gotten some great key points that have come through. One of the things that I took away is, how can we make sure we're people first? You know, Ahmed Saeed had highlighted, look, we have to train our lawyers, our judges, on how to handle digital cases. And you remember at the beginning of this Tashkent Law Spring where they showed the video? I don't know about you, but I had to do a double take because some of the people on there looked real. And I was wondering, are they real people? Are they AI people? And you can imagine someone joining a video call and asking, hey, maybe you'd like to transfer some funds, and then the funds get transferred, and was it a real person? Oh, wait a second, that happened in Hong Kong. That's a real case, actually. And so do we have the laws in place to manage that as well? All right, let's begin to bring up our second panel. And I'm going to start off with Mr. Farid Akhmadov. Please, let's welcome. And now, let's introduce Mr. Azim Tarar. And next we have Konstantin Chuchenko. And His Excellency Lucien Wang. Mr. Hong Yu Fu. And finally, Carolyn Lam. We'll hear first from Mr. Akhmadov.
Thank you very much indeed. I first would like to join my colleagues in expressing heartfelt thanks to the organizers of this event, my brother Akbar. He has been instrumental in putting this together, and thanks to his team for throwing this wonderful event. Now I have a challenge. Obviously, the challenge comes from the fact that I have to speak, or we all have to speak, after 6 prominent speakers who have already touched upon most of the things. So perhaps I will need to do impromptu some of the things and pick up on the points that have already been made. Now, the colleagues have referred to the role of the AI in the legislative drafting process. My colleague from the United Arab Emirates, there have been some points made regarding the role of technology in the rule of law, for the rule of law, and some of the aspects relating to the trainings that are very much important, and the colleague that from Malaysia has made the point. Indeed, perhaps the key question is, what will happen to the future of the legal profession? Now, when the AI is being applied in all of the fields that have been mentioned, will we be employed as lawyers, as justice ministers to start with, in few years' time? Now, so how will the profession transform? Will it fade away, or it will transform and require skills that lawyers do not have today? So what should we do about that? Now, I think obviously, AI is fundamental, as has been said, in generating text, if we're talking about generative AI, for the purposes of lawmaking, for the purposes of adjudication. We have tools now that are generating standardized texts for the court judgments. Some of the good examples come from the European Court of Human Rights. Obviously, AI is used to analyze voluminous data in the case files that is of very much assistance to prosecutors, to practicing lawyers, and to judges. Now, and it is instrumental in solving these days very simple cases, disputes. But I think if you look at the lawmaking process, at the process of adjudication, it's so much beyond generating simple text. It is so much more nuanced, it's so much more complex. The lawmaking process is often beyond the law. It takes into account sociology, anthropology, behavioral economics, so many different disciplines and areas it transcends to, that a law becomes just one of the aspects of the lawmaking process. The same is true of adjudication, because adjudication at the end of the day is not mere application of law. It's a very complex and nuanced process of delivering justice. Sometimes laws are unjust, and when laws are unjust, and history has shown many examples of laws being unjust. You have US segregation laws, which were laws enacted by the parliament, but they were unjust, and it took a courage of a sound-minded, reasoned judge to declare them unconstitutional or to be in conflict with mere reason or natural law. So it is definitely so much beyond mere formulation of text, aggregation of text, generation of text. It's much more nuanced and much more complex. So it definitely, therefore, requires for us to educate new generation of lawyers that will be able to benefit from the technology that is being used today or will be used in the future, from AI, but also be able to maintain those fundamental skills that are needed for a lawyer, that is creativity, sound judgment, empathy, that AI will not perhaps have, as I understand it, in order, and bring all these skills together. Now, obviously this raises a huge fundamental question about the future of legal education. What will happen with legal education? What should law schools do in order to bring these two separate skill sets together? Knowledge of technology, ability to use technology, and maintaining these fundamental skills and competences and faculties that are needed for a practicing lawyer or a judge. So this will require a transformation of the law schools. It is easier said than done, obviously. Law schools are normally very conservative in bringing about changes, and it will require, obviously, bringing in interdisciplinary curriculums for the law schools, something that is ordinarily not expected from a law school. Now, law schools will have to perhaps, and I see some of the recently established law schools or some of the old law schools that are now changing their curriculums, bring in subjects such as compulsory courses such as data analysis, such as basic calculus. So they're introducing quantitative skills or courses that will teach quantitative skills to future lawyers so that when they graduate, when they enter legal practice, they are capable of juggling with complex technological tools, but also be able to apply what is required from a practicing lawyer. So therefore, training is fundamental, obviously. Some of us who have already gone to law schools and will not be able to return to law schools need to fill that gap of knowledge and competence now. And that it means the countries have to launch entire training programs to upskill the judges, to upskill the lawyers, and obviously to educate the future generation of lawyers so that we do not end up in a situation where there's huge discrepancy of competences within the legal community, which will eventually, if happens, undermine the rule of law of which Mr. Lewis was talking about. I thank you very much. I think my time is up.
Thank you. Thank you, Mr. Akhmedov, and I really love how you went right to the point. We need to change even the law school. This is a big statement to have technology and law combined. Can I just ask a follow-up question? How is Azerbaijan actually putting that in place? Just a quick 30-second answer, if you don't mind.
That's exactly what we are doing. We are starting with education. We are basically reviewing the law school curriculums and looking at it in the perspective not only of legal education, but also in terms of, and I have my colleagues here from Bar Association of Azerbaijan, how the exams into the bar associations will be held. Because if you change your law school systems, eventually you have to have a follow-up system in place to reflect your changes in the law school. So we are implementing reforms in this field. It's not easy, but I think we are on the right track.
All right, thank you so much. Now let's turn the time over to Mr. Tarar. Go ahead, please.
Assalamu alaikum. First of all, thank you so much, Brother Akbar, for bringing us together in such an illustrious gathering. And I will join my brother Fareed to congratulating you and your team. It's a new world, and we are actually entering into a modern and new world. I will start by narrating a verse from our national poet, Iqbal Lahori. He wrote in Urdu and Farsi 110 years back, and he said that Jahane Taza ki afkare taza se hai namood, ke sango khish se hote nahi jahan paida. That modern world is not built by brick and mortar. It's the modern thought which makes the new world. So we are standing at a new juncture where we are confronted with many challenges, including adaptability to the technology. The region of the world from where I come from, it seems difficult that it's so easy to adapt to artificial intelligence, as my colleague from Azerbaijan said in adjudication. But I'm also one of the very positive persons. I'm very optimistic about it, that, well, when the computer age started 2 or 3 decades ago, things seemed extremely difficult to us. And for the older generation, it was a thing which was not acceptable. But now with this small gadget in your hand, which is the smartphone, it has changed your lifestyles. You want to know about anything, any person, you just have to click and you get answers. Well, it's kind of a strange thing that you start thinking how this gadget would decide a dispute between 2 individuals, deciding their rights, because first we look into the facts of the case, then we apply the relevant legal provisions, then we also try, you see the scales of justice, so you have to balance the scales. Now, being a just and fair person, you always try to be fair and just to the parties. Now, the question would be how a system or a machine would be analyzing everything and coming, yes, it is possible, but at the same time, it's a greater challenge. So let the time answer this. Let's start experimenting it from trivial issues, the issues which we can discuss and we can refer to such kind of solution. The other thing which has been actually broadly highlighted by our sister from UAE, that use of technology in legislation, informing technology, informing policies, the regulatory affairs. Yes, it's very beneficial in Pakistan back home. We have tried this, and alhamdulillah, the results are very positive. We have now revisited our curriculum in the law schools, as my brother from Azerbaijan was referring to. we are introducing these subjects in our legal education. In my country, you have to stay 5 years at the law school after completing your high school. So it's 12 plus 5 years, 17 years of education. So we have dedicated a great number of hours to these new concepts in the law. We need time to educate further the teachers, the students, the lawyers, the judges. Yes, in the courtrooms, we are now relying on the research tools which in vogue everywhere in the world. We have created our own law sites which help you out in collecting material for preparation and decision of your cases. Likewise, the case management system is also one of the things which makes your life so easy. In our country, having 250 million people living there, and like the many other common law countries, we are so fond of bringing our matters before the courts. So one thing is how to actually filter those cases which need not to be brought before the courts. For that, you have the systems in place and actually working on the lines that these matters can be straight away referred back to some other authority or alternative dispute resolution forums. So this task is being undertaken by the technology in most of the jurisdictions, including myself. The other is the digitization of the laws. So as I said, that the information is in your smartphone. We have also compiled, and it's now successfully launched. It's the app called Pakistan Code. So starting from year 1858, when while the British rule, the laws were started to be legislated, till to date, like 2025, we have digitized all laws, amended up to date, and now those are available on the Apple and Android. It's called the Pakistan Code. And we also claim that any amendment made in the law with comparative table is also displayed on the screen with a click of button. So these are the benefits actually we are having from the technology. Coming back to the bright future of technology in the lawfare, including the artificial intelligence, yes, once again, I would revert back to many questions in my mind as student of law, that would it work? What are the areas we can actually explore in? Of course, all jurisdictions are trying and are actually fighting with different kind of debates, different angles to be seen. But such kind of forums and places are the right places where we can share our thoughts, positive, negative as well, so that we can see the pros and cons. So while concluding, I would say that good luck for a technological, digital future of the lawfare across the globe, and all of us should be those who actually want some kind of a balance in technology and application of laws. Thank you so much for inviting. Thank you.
Thank you for your encouraging words. Mr. Chuchenko.
Добрый день, уважаемые участники форума. Я с своей стороны тоже хотел бы прежде всего поблагодарить Министерство юстиции Республики Узбекистан за безукоризненную организацию сегодняшнего мероприятия, ну и проявленное очень радушное гостеприимство. Неделю назад завершился Петербургский международный юридический форум. На нем мы тоже обсуждали роль права для будущего, и отрадно, что нынешний Ташкентский форум продолжает дискуссию о месте права в мире, но уже в новом ключе, в фокусе цифровых технологий. Юстиция не должна быть в роли догоняющего. Напротив, каждое направление, будь то нормотворчество, правовая помощь, адвокатура или исполнительное производство, должны задавать цифровые тренды. Однако перевести юстицию в цифру по шаблону невозможно. Цифровизация должна являться не самоцелью, а средством повышения качества жизни граждан. Это видно на примере госуслуг, юридической помощи и регистрации актов гражданского состояния. Минюст России разработал и ввел в эксплуатацию информационную систему «Правовая помощь», которая позволяет быстро, качественно и своевременно оказывать такую помощь в удаленном формате. Важная часть системы – это единый государственный портал правового просвещения и бесплатной юридической помощи в праве.рф. С его помощью граждане могут ознакомиться с актуальной правовой информацией. Сегодня на портале размещены уже более 250 жизненных ситуаций, которые затрагивают наиболее важные для наших граждан вопросы. И надо отметить, что количество посетителей портала кратно растет, и за прошлый год оно увеличилось более чем в 5 раз. Цифровые инструменты внедряются и российскими адвокатурой и нотариатом. Внесенные недавно изменения в законодательство позволяют нотариусам совершать отдельные действия дистанционно, а бумажные документы передавать в любую точку страны в виде заверенного электронного образа. Цифра пронизывает и российскую адвокатуру от сдачи адвокатского экзамена до распределения заявок следователей, дознавателей судов для участия адвокатов в судопроизводстве по делам, так называемым, по назначению. В сфере ЗАГС достигнут высокий уровень цифровизации, для граждан повысилось удобство и комфорт при получении услуг. Это стало возможным благодаря единому государственному реестру записи актов гражданского состояния. Мы координировали работу по конвертации в электронный вид и передаче в реестр ЗАГС, начиная с 1926 года, документов, которые хранились на бумажном и электронном виде. Сейчас реестр работает на всей территории России и на данный момент включает в себя уже более 560 миллионов записей. Создание единого государственного реестра ЗАГС стало по-настоящему прорывным событием. Его возможности позволили подготовить масштабные изменения в законодательство о регистрации актов гражданского состояния. С декабря 2021 года внедрен экстерриториальный принцип в работе органов ЗАГС России, и граждане могут обратиться в любой орган для получения нужных документов, независимо от своего местонахождения. Кроме того, обеспечено межведомственное электронное взаимодействие между органами, предоставляющими государственные и муниципальные услуги. Например, стало возможным осуществлять государственную регистрацию рождения и смерти по медицинским свидетельствам, составленным в электронном виде. С мая 2022 года начата регистрация рождения ребенка без личного посещения органа ЗАГС в рамках суперсервиса рождения ребенка. Отмечу, что сегодня одним из основных подходов в развитии Института государственных услуг является постепенный отказ от бумажных документов. Поэтому мы продолжаем работать над реализацией новых перспективных цифровых решений в сфере ЗАГС. В частности, это переход на реестровую модель предоставления государственных услуг органов ЗАГС. Внедрение такой модели сведет к минимуму бумажный документооборот и поспособствует дальнейшему переводу услуг органов ЗАГС в электронный вид. Источником юридически значимых сведений о правовом состоянии гражданина станет только запись в реестре. Пропадет необходимость оформления бумажного документа, при этом выписку из реестра в электронном или бумажном виде в любой момент можно будет оперативно получить, направив соответствующий запрос через портал государственных услуг или лично придя в орган ЗАГС. Реестровая модель также должна заработать и в системе исполнительного производства. Это позволит исключить бумажный документооборот исполнительных документов, появится возможность осуществлять принудительное исполнение на основе юридически значимой информации, получаемой из единого государственного реестра. При этом изготовление, выдачу и направление исполнительных документов предлагается упразднить их заменит юридическая информация из реестра. Внедрение реестровой модели принудительного исполнения повысит эффективность исполнения судебных актов, актов других органов. Кроме того, сократит количество личных контактов сторон исполнительного производства с должностными лицами и снизит операционные издержки. А самое главное, повысит уровень комфорта государственных сервисов для наших граждан. Это выведет на новый уровень работу приставов, которые уже сегодня используют технологии идентификации должников, автоматического внесения процессуальных решений, онлайн взаимодействия с гражданами и госорганами. Остро стоит задача модернизации пенитенциарной системы и следственных изоляторов. Их эффективность должна измеряться не толщиной бетонных стен и арматуры, а технологическими решениями. Мы внедряем на объектах системы видеонаблюдение, идентификация, а также выявление девиантного поведения. Эти меры уже позволили пресечь ряд попыток побега, суицида и беспорядков. Новые вызовы диктуют необходимость адаптации нормативно-правовой базы. Как известно, цифровые активы обретают все большую популярность в преступной среде, поэтому в этом году мы разработали законопроект для ареста и изъятия такого имущества в уголовном судопроизводстве. Важным проектом является внедрение искусственного интеллекта в экспертизу тысяч проектов нормативных правовых актов, которые проходят экспертизу в Минюсте России. Их эффективное рассмотрение во многом зависит от производительности труда. Искусственный интеллект помогает нашим служащим, например, подсвечивая возможные коррупциогенные факторы, но оставляя окончательное решение, конечно же, за человеком. Неизбежна цифровизация международного сотрудничества. Тесные трансграничные связи, прежде всего на постсоветском пространстве, сконцентрировали наши усилия на цифровизации оказания международной правовой помощи. За каждым пересылаемым между государственными документами стоит судьба конкретного человека. Любой, кто истребовал документы из-за рубежа, пытался исполнить судебные решения, неизбежно сталкивался с бумажной перепиской. Эту ситуацию нужно срочно менять. Срок обмена документами должен измеряться не месяцами, а часами. Бумажная волокита совершенно недопустима, и поэтому мы высоко ценим инициативы Республики Узбекистан по цифровизации правовой помощи на площадке СНГ. Одновременно считаем важным подключить к этой работе интегрированную информационную систему ЕАЭС. И позвольте некоторые выводы обозначить. Можно еще долго говорить о процессах цифровизации, однако закономерно возникает вопрос, и он является главным, а дойдем ли мы до той грани, когда машина заменит и нас с вами, живых юристов? Возможно, но лишь отчасти. Безусловно, цифровые решения выигрывают конкуренцию с людьми в части типовых и рутинных задач. Но даже самые продвинутые технологии, искусственный интеллект, основаны на обучении. Исчезнет фигура юриста, и компьютер будет некому учить. Важно и другое. Работе юриста присущ неуловимый для двоичного кода элемент творчества и критического мышления, нравственной оценки. Меняется жизнь, меняются общественные отношения, и наша обязанность создать норму права, искать новые правовые смыслы, добиваться справедливости, работать с людьми и для людей. Найти правильное решение нам позволяет не только образование, но и жизненный опыт, неравнодушие и межличностное общение. Этому компьютер не научить. Поэтому задача юриста в эпоху новых технологий – сохранить право с человеческим лицом. Я хотел бы пожелать всем участникам форума успехов и поблагодарить за внимание. Спасибо.
Spasiba, Mr. Chuchenko. Thank you. One of the things you highlighted was that we won't be able to have an AI replace humans as yet because of the feelings. It's something for us to continue to experiment with for sure. And I'm looking forward to seeing this transition to make sure that AI is not seen as a replacement for humans, but rather as a collaboration. And with that, let's turn the time over to His Excellency Lucien Wong.
Your Excellencies, distinguished speakers and colleagues, ladies and gentlemen, let me first express my appreciation to the Minister of Justice of the Republic of Uzbekistan, His Excellency, Tashkent, for this kind invitation to this year's Tashkent Law Spring. It is my pleasure to be in this historic city and to speak to you about the digital transformation of justice and Singapore's response to technology-related crime. It will come as no surprise to all present that just as much as the latest digital innovations have changed how we live and work, these same technologies are being exploited by criminals. Innovations in generative AI, such as deepfakes and large language models, have allowed the bad actors to advance their old criminal methods and have given them completely new tools for the criminal enterprises. I'm pleased to have the opportunity today to share with you Singapore's experience in relation to the digital transformation in technology-enabled crime and how we have had to transform our legal landscape to combat this threat. Singapore is one of the world's most digitalized populations. While this connectivity drives our success, it also makes us vulnerable to technology-enabled crimes that exploit our open and digital economy. And the scale of this vulnerability is significant. For example, in 2024 alone, victims in Singapore lost 1.1 billion Singapore dollars, that's approximately US $850 million, to scams. Criminals are increasingly employing AI technologies like deepfakes and large language models to conduct convincing scams. And we have also experienced that cyber criminals are not only leveraging on new technologies, they are also doing so in organized criminal groups. Singapore's response to the digital transformation of crime has been decisive and comprehensive. Let me outline just two key aspects of our strategy in combating these crimes, namely legislative changes and the enhancement of our law enforcement operational capabilities. First, legislative changes. We have strengthened our legislative framework by introducing novel laws to target scams and cybercrime. I'll just give you 3 examples. One problem Singapore initially had was prosecuting money mules who provided bank accounts or even facilitated money transfers limited to scams. It was in the past difficult for us to prove the requisite criminal intention to facilitate criminal activities by money mules. And to close this gap, in February last year, Singapore implemented new provisions under our laws, and the amendments introduced by these provisions are novel offenses targeting rash and negligent money laundering, as well as criminalizing the disclosure of our national digital identity credentials to enable criminals to use the innocent victims' bank accounts to launder the funds. Now we have these legislative changes to serve to combat and deter would-be money mules that scammers rely on to launder the proceeds. Next, beyond targeting money mules, Singapore has also introduced unique legislation to target online crime at the source. In February last year, we introduced acts in Singapore which empowers our law enforcement agencies to issue directions to disrupt access to criminal online activities, regardless of whether the perpetrators are located within or outside Singapore. Our law enforcement agencies can now direct online service providers to cut off access to or to take down such online criminal content. And a third example is this: to protect scam victims themselves. Some scam victims, are so convinced that they are not scammed when in fact they are. And they persist to believe in the lies of the criminals and transfer monies to them despite interventions from family, friends, and even the police. So in January this year, Singapore passed the novel legislation which allows law enforcement agencies in Singapore to issue restriction orders which lasts a maximum of 6 months to prevent stubborn victims from accessing the bank accounts to transfer monies to scammers. Secondly, our enhancement of our law enforcement agencies' operational capabilities. For example, we set up an anti-scam center, and this has remarkable success. And the center has launched initiatives to cooperate with like-minded agencies in trying to combat transnational cyber crimes. Just an example would be a project that the center had launched, which created an alliance with similar anti-scam units across various countries. Between June 2021 and December last year, the center worked with counterparts in Malaysia, China, Taiwan, Hong Kong to bust 64 transnational scam syndicates with 491 arrests overseas and 160 arrested in Singapore. I've said much about digital advances, how they've transformed the criminal landscape. However, these technologies, particularly AI, can also be harnessed in our own legal work. And my chambers is developing in-house AI tools, as well as working with commercial partners to explore and incorporate the use of AI in our work. But in leveraging the use of AI, we must, of course, be cognizant of the risks involved. AI is no replacement for the skill and discernment of our legal officers, who must be alive to the risk of inaccuracy or even hallucinations. Now, I will conclude. The digital transformation of criminal activity demands a corresponding digital transformation of justice to not just keep up with, but to stay ahead of criminals. Singapore remains committed to this evolution, ensuring that our legal and enforcement framework keeps pace with technology change while maintaining the fundamental principles of justice and the rule of law. Thank you.
Thank you, His Excellency Lucien Wong. And AI is not a replacement for our legal departments. And I want to add the word yet. I just need the clicker. There we go. Thank you very much. Here you go. Now we'll bring up Mr. Hong Yu-Fu to share his perspectives. Thank you for joining us. Go ahead.
Okay, thank you very much. Respected Excellencies, distinguished guests, it's my pleasure to be here and share some of my views about this, I think it's very important cutting-edge topic about law and AI. Please put on the slides. Okay, so first I want to introduce myself a little bit. I'm from Alibaba and from the think tank which is called Ali Research. And my responsibility in Ali Research is oversee Alibaba's AI governance. So before I joined Alibaba, I work as a lawyer, being licensed in United States and in China, and I also work in academia. So I think I have a lot of understandings about when we talk about the AI law. Of course, I'm an expert and a drafter of Chinese AI law recommended version. So in China, actually, we have a pretty comprehensive legal regulations about AI. First, we have AI promotion law, because we think that, well, AI promotion and innovation is very important, and law should serve innovation, right? And second is that, of course, we have the risk-based regulation on AI. We have regulations against algorithm recommendation, against deepfake, and against generative AI, which is large language models. And right now we have a law on watermarks, means that we have to make AI contents traceable. But today I want to share another view on the interrelationship between AI and law, which is AI and judicial practice. So I want to give you a very quick number about one trial court judge in China, the amount of cases he handles or she handles. And you can guess about the number. So the average number of cases trial court judge handled in China back to 2023 is 274. They handle 274 cases, and some of them handles more than 400 cases a year. So we have this kind of a huge caseload. You can see that we have 110.8 million trial and enforcement cases each year, and it's growing fast. So we need capability. And of course, by that time, our trials are getting more and more complex. We're getting more and more international trials, commercial arbitrations, and complex litigations. So we have to ensure professionalism across our judges as well. And the most important part is that China is moving fast into a social media age. So we have a lot of exposures of the cases, of the trials, and the public needs responses and needs responsiveness of the court system. So I would say that we are facing a dilemma, a kind of an impossible triangle between efficiency, responsiveness, and responsibility. That's where our smart court system or intelligent justice court system kick in. So we have a three-staged developments. Actually, we started digitalizing our court infrastructure back to 2014. So now we have like 3,500 courts nationwide have full coverage of online case filing, handling, and office work. And the next step, we move into a data-driven network. We kind of consolidate all the data. And data is very important. So we use data for drug enforcement, and we gather like 429 clues on that. And now, where are we? We move into an AI-driven smart court system. So we really are using AI, or more specifically, we are using generative AI. What about generative AI? What's the applications? The first is that we use multimodal understanding, because evidence gathering and evidence discovering is very important for sound judicial decision making. So we use AIs to compare the evidence. Now we have like 9,000 cases in duplicate content, and we use AI technology to compare the differences to make sure that whether there is kind of copyright infringement. And second is that we will have the content generating reasoning analysis, because right now AI moves to a reasoning stage where the system can reason step by step. We call that COT, or chain of thought. So we are utilizing that technology to analyze the cases to make the reasonings more sound and make sure that there are no flaws in the reasoning. And third is that we want to make sure that our court system, not the system, but the information is publicly accessible. So we'll have this kind of a agent or chatbots, but they interact with the public more often. They can be 7/24 all the time. So whenever there's a question about the case or opinion of the case, that AI assistant can answer their question. Of course, we are not only using AIs in court systems, we are using that in legal practices. This is the 通义法律, which translates into intelligent law, which is a foundation model specifically fine-tuned for legal practices. We use that for contract drafting and review, which is right now is very inexpensive in China. You can generate a contract within 20 seconds. And it's almost flawless. Of course, there will be like trial documents drafting, and they will use so-called vector-based legal research. Because AI cannot memorize all the legal terms and all the legal requirements or the legal texts, so we'll use so-called retrieve-augmented generation technology to make sure that whenever there is a legal research, the information is up to date. And we, as I mentioned, we use COT-assisted legal analysis. And we are not only use AI in legal practices, we are also using AI in legal education. This is the CIS, the Chinese Academy of Sciences. They have this so-called agent court, which they use generative AI to help law schools to use in mock trials. So now in mock trials, you can interacting with AI, which can be adaptive to your flaws and your strengths and make improvements to your arguments. So finally, my note is that, well, because we are in a cutting edge of moving into an AI age, and we want to look at the law and AI. And I would say that we should have a co-evolution perspective on their relationship. First, that law promotes AI innovations and AI empowers law. Is that my first impression is that, well, we as lawyers, as legal practitioners, we should take AI as law's client because it's our duty, it's law's duty to promote innovation, right? So actually, law secures AI innovation and development. As Premier Li Qiang said in 2023, that non-development is the greatest insecurity and non-cooperation is the greatest risk. And of course, law makes sure that AI works along with established legal principles. And of course, we should, on the other side, AI better serves legal justice because AI supports, not replaces, legal adjudication. So we should not looking at the replacement, but looking at how to make sure that AI is people-oriented, as a lot of distinguished speakers have pointed out. Make sure that, well, AI improves judicial credibility and trustworthiness. So I'm putting forward these questions to our distinguished audience, and I'm looking forward to answer the questions with you. Thank you.
Thank you so much, Hong Yu-fu. What exciting developments. I love how you're using the AI to do training for the next generation of lawyers, and that's showing them what it can and can't do, right? There's places, like you said, it makes mistakes. And that's what, again, we've heard from previous speakers, how the judicial area needs to understand what this is all about, right? So let's turn to our last panelist here that's with us. Please.
Thank you. Thank you very much. And it's a delight to be here and witness again transformative change in Uzbekistan and globally. And I'm not going to repeat a lot of things, but I'm going to make a few observations for all of us as we think about this fast emerging area. And as members of a global society and community, we have a responsibility to be sure that with all of this, we preserve the rule of law and enhance access to justice. And we heard a lot this morning already from OECD and the World Justice Project about how we can enhance access to justice by some of the modalities presented by AI. But we have to realize that a lot of the innovation has raced ahead, but the regulations that really control AI have not. It's regulation of any use, confidentiality, transparency, reliability are just getting started. And we've seen many, certainly Uzbekistan has led the way with the presidential decree and the recent legal changes. But there is, and I'm going to mention a few of those things in addition to Uzbekistan, but there is a blurring of lines, I would say legally, in terms of what is defined as AI under the law and what's not. And the laws are ever changing and evolving as the technology changes and evolves. And there is not any, at this point in time, consistent global regulation. It cries out eventually for a treaty where all of the countries can come together and agree on whatever regulation there may have to be. But national laws are certainly emerging in some jurisdictions. The European Union has most recently passed the EU AI Act. I'll leave it to my EU colleagues to discuss it in detail, but let me just observe it's not a model of clarity, and it's certainly, you see the European Court of Justice making certain opinions that seem to maybe enhance the regulation or change the regulation. So this is a fast-changing area. In the United States, I would observe, there is not any comprehensive federal law on AI. It's simply not regulated. We've had Senate hearings. We've had agencies investigating the appropriate model. So far, it is left to the existing federal laws on privacy, which is an important aspect, consumer protection, which is, again, an important aspect, which is left to the existing rules at the FTC that really relate to fraud and misrepresentation and what you're being told and sold. And, you know, some of the discrimination statutes. We do have a new executive order removing all barriers to AI, but we don't know what that means. We'll see this evolve. I think in looking at some of the uses of AI globally in the judiciary, one of the most interesting, and I think an excellent approach at the International Criminal Court, Project Harmony, which in fact uses AI for rapid pattern identification, translations, facial identifications, image enrichment, transcription of media files. All of that helps the justice system. It can't replace the justice system and the human capacity to decide those things, but to have all of those things computerized, summarized at your fingertips as a decider of fact, decider of law, or an advocate is extraordinary. We've seen China, of course, making advances with the internet courts, but recalling that, of course, this is a technology that is based on words. It compares words. It's algorithmic. I don't think we are yet at the place where it adds the human judgment in decision-making. Maybe we'll get there. But I think to protect justice in our society, we really need to be attentive to the uses. In the international arbitration area, many of the arbitral institutions, JAMS, AAA, I think the Chartered Institute of Arbitrators is perhaps the best in terms of providing guidance. But there, they warn the arbitrators and the parties and the advocates how to preserve the enforceability of the award, what should go in a procedural order so that you know if the other side is using AI, the judge is using AI. And why is that all important? Because to use it means you've got to feed all of the evidence, feed the legal arguments into the system, which really impairs confidentiality, transparency. You have to know and understand data storage, privacy issues, etc. So it's not turning on a light switch in terms of the kinds of impact that the uses may have. So I think generative AI certainly promises to be an incredibly valuable tool to professionals, and you ignore it at your peril. Like all powerful tools, like a sharp knife, it can be used with great help and efficiency to effectively provide in an expedited way services for clients with respect. But if used inattentively, inappropriately, it can cause great harm. AI certainly enhances access and could improve outcomes because you have the data to make the decisions and do the analysis. Saves huge time. And really, you must safeguard, though, against bias. It is not correct in many of the instances, and it cannot replace what is irreplaceable, human judgment. So as all members of the global community, we must approach with a balance and a fairness to how we regulate it, what we do with it, and understanding it will replace tasks, it will enhance performance, but what it doesn't do is replace humans.
Congratulations on the successful opening of this international legal forum, the fourth Tashkent Law Spring, organized by the Minister of Justice of Uzbekistan. Japan and Uzbekistan have been cooperating in the field of law and justice since 2001 and have been building a very good relationship. The Ministry of Justice of Japan shares the importance of the rule of law with the Ministry of Justice of Uzbekistan, which we regard as an important partner country. Based on this strong relationship, we are very pleased that Uzbekistan is taking the lead in organizing this excellent forum to address issues of great importance to the international community. We recognize the significance of the Tashkent Law Spring as a pivotal platform for dialogue among experts from diverse backgrounds. We believe that this forum holds immense potential in fostering understanding and collaboration, particularly in addressing contemporary issues of mutual concern. In recent years, the speed of development in digital technologies, as characterized by generative AI, is remarkable, and digital technologies are increasingly used in various areas in the field of law and justice as well. Therefore, it is important to explore the potentials and challenges related to the use of digital technologies to address challenges in this field, bearing in mind that the mobilization of digital technologies in the legal and justice process entails both positive and negative aspects. In Japan, digitalization in the field of law and justice is gradually progressing in certain areas. We hope to contribute to the discussion regarding the digitalization of the judicial system in Central Asia by sharing our knowledge and experience with you. At the same time, we look forward to learning from the discussions that will take place in this forum. In this light, we are honored and pleased that a professor of the International Cooperation Department of the Research and Training Institute of the Ministry of Justice and a professor of Nagoya University have been invited to join this forum as panelists. Finally, I would like to extend my best wishes for the success of this forum. I'm convinced that this forum will serve as a great opportunity to exchange good practices, views, and perspectives. Thank you for the attention.
Thank you, Minister from Japan. And now, as we wrap up here, I'd like to, again, give 30 seconds to each one of our panelists up here to hear some of their key thoughts as to what they would like for you to take away today and continue on how we can work together and grow together. Who would like to start first?
I'm just wondering if a moderator was an AI-operated robot, would it give me extra 30 seconds? Because I was already given 30 seconds before at the start. So I think you are discriminating between the colleagues here. But okay, thank you for giving extra 30 seconds to me. I think the key, given that we don't know what challenges the digitalization and AI is posing, we can only make predictions about that. We just need to keep our, since I was speaking about education, legal education, we just need to keep our minds flexible and open and make our legal education adaptable as quickly as possible to these challenges that we can't even foresee at this stage. So I think adaptability and flexibility of the legal education is a key. Thank you.
Right. Thank you so much.
Yeah, thank you. I think we are the generation which has seen the transition. We started our lives with writing letters, then connecting through landlines, then the mobile phones, smartphones, computer life. So we should be very optimistic, and we should use these tools to make life of people easy. We have thousands and thousands of cases in pendency. The systems are clogged. So let's use these tools and technologies to make life of the litigant better and better. Yeah.
Okay, thank you.
Ну, сегодняшняя дискуссия в очередной раз показала то, что искусственный интеллект – вещь абсолютно необходимая, да, и с одной стороны он повышает эффективность работы государства, а с другой стороны он служит интересам наших граждан. Но в то же время мы, как мне кажется, должны все понимать, что искусственный интеллект больше является формой, нежели содержанием. Да? Содержание вот всей этой работы должен определять все-таки человек. Да? И профессия юриста, она не вымирающая абсолютно в связи с внедрением искусственного интеллекта, а просто, мне кажется, мы все перейдем точнее, на совершенно другой уровень. Да, ну и, соответственно, искусственный интеллект никогда не заменит судью как человека, потому что все-таки должен быть опыт, должна быть душа, должны быть эмоции, должна быть нравственность.
Two quick points. I believe that for us to combat technology-enabled crimes, we must continue to strengthen international cooperation. As you know, technology-enabled crimes are usually cross-border, and no one country on its own can successfully combat those sort of crimes. Next, we must also continue to invest in our capabilities to prosecute increasingly complex technology-enabled crimes. Thank you.
Well, I also have 2 points to make. The first is that I think law and AI actually are made by humans. So they can go to the same end to make our human beings better. But law and AI may operate differently. So I think we should have this kind of communications to make sure that on both sides can understand each other, right? Lawyers and IT guys, they should sit down together and talk about solutions to make sure that, well, AI serves for the better human future. I think that's one point. And second point is that I want to emphasize that The AI responsibility and AI safety is a global public good. I think we should be open to all the risks posed by AI, to all the issues created by AI. And we should enhance international cooperation on dialogues on technical solutions to those questions, to those issues posed by AI, because that's something our human beings are commonly facing with. So enhance international cooperation and making AI as a global public good will be the ultimate solution. Thank you.
There's an amazing amount of agreement here. In any event, it's, I think, incredibly important as we all use the benefits of artificial intelligence to continue to preserve the confidentiality, the privacy, the consumer rights, as well as due process for all the participants in the legal system.
Very good, Caroline. Wow. Well, this has been an amazing couple hours walking through how AI is transforming our legal profession. And I wanted to capture some of the key points from the beginning from Her Excellency Al Hamadi, where she talked about what's happening in the UAE and the transformation there, and that 85% of laws being updated as well. And what we heard there is what gets measured gets improved as well. And then we heard from Her Excellency Ahmed Saeed about the importance of developing people in order to protect even our children, and how our legal profession needs to be aware of digital crime. And that connected up very much with His Excellency Lucien Wang as well, and the cyber security issues that have been going on. And living in Singapore myself, we've seen so many people get scammed, and being able to pinpoint the law that needs to go after those criminals makes it more efficient and safe in a time that we can't avoid digital transformation, actually. Tiplova highlighted we need to be people first. That's so critical for us. And ultimately, Mr. Nettle highlighted how we can collaborate together. You are not in this alone. Large organizations are able to come in neutral ground and do like a public good, which is we heard as well. And ultimately, training, being able to look at our pinpoint changes in law, collaborating human first. AI is not a replacement for humans, but a great co-pilot in all aspects of legal. And finally, I'd like to say that justice is not truly blind until the smallest company and the least of us gets a good representation in their day of court. And all of us can make a difference in that. Thank you all for this wonderful panel. Okay, now don't anyone leave. We have a little bit of fun. First of all, I'd like to invite the VIPs up to the stage here, and our panelists from the first panel and this panel session, so we can take a photo. But don't anyone leave, because we're also going to take a photo of the whole group here. So please, panelists, join me, and VIPs, come on up to the stage here. And now we need to do one more thing. If I can ask the photographer, the official photographer, to come up on stage, please. And then what we'll do is take a picture from this way of the whole audience with us as well. So
Раз, два, три, четыре, пять, шесть, семь, восемь, девять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять. Раз, два, три, четыре, пять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять, десять. Раз, два, три, четыре, пять. Один, два, три, четыре, пять, шесть, семь, восемь, девять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять, десять. Раз, два, три, четыре, пять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять, десять. Раз, два, три, четыре, пять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять, десять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять. Один, два, три, четыре, пять, шесть, семь, восемь. Раз, два, три, четыре, пять. Раз, два, три, четыре, пять, шесть, семь, восемь, девять.
Assalomu alaikum, hurmatli tadbir ishtirokchilari. Good afternoon, distinguished colleagues, fellow practitioners, and esteemed guests. Welcome to what promises to be one of the most thought-provoking sessions of Tashkent Law Spring. I'm honored to moderate today's discussion on artificial intelligence or human who will win the arbitration, a question that sits at the very heart of our profession's future. I am Islambek Rustambekov, Professor and Doctor of Law, Director of the Tashkent State University of Law, and I am very glad to moderate this session. We stand at an unprecedented inflection point in the history of international arbitration. The rapid advancement of artificial intelligence is not merely knocking at the door of our legal chambers. It has already entered, settled in, and began reshaping how we practice, how we think, and perhaps even how we define justice itself. Today's session will explore fundamental challenge where the AI represents the ultimate tool for enhancing human capability or a fundamental challenge to the human element that has long been the cornerstone of dispute resolution. I think we all have a lot of questions for the speakers of today about AI and how it could be used or not used, or can it change the human in arbitration. Before we embark on this intellectual journey, allow me to introduce our distinguished panel of experts, each bringing unique perspectives from the front lines of this technological revolution. Our first speaker is Caroline Lamb, a partner at White & Case and one of the most distinguished names in international arbitration globally. Chambers describe her as having unsurpassed knowledge and practice in international public law and international investment arbitration, with clients noting that she's superwoman, and I agree. She's fabulous and you couldn't find a better counsel. Beyond her stellar practice representing international corporations and sovereign clients, Caroline serves as distinguished faculty chair at the University of Miami's White & Case LLM program in international arbitration and is a fellow of the American College of Trial Lawyers. Her connection to our region runs deep. She serves as honorary professor at Tashkent State University of Law, and we are honored with that, and was appointed by the government of Uzbekistan to the Uzbek panel of arbitrators for ICSID arbitration. Caroline also has a medal on friendship from Uzbekistan, and Caroline will address the critical ethical dimensions of AI in arbitration. Next, we have Andrea Pinna, founding partner of Pinna Goldberg, with expertise spanning more than 50 arbitration proceedings across sectors including M&A, oil and gas, mining, and military disputes. Chambers recognize Andrea as truly an excellent litigator with unbelievable work ethics and a great legal mind, particularly noting his exceptional ability to think outside of the box, to be imaginative and at the same time be attentive to detail. His firm has rapidly expanded from Paris to London, Washington, D.C., and notably is opening its office in Tashkent, demonstrating his commitment to our region. Andrea will explore the practical applications of AI in drafting pleadings and legal documents. Our third panelist is Charles Claypool, a leading arbitration and international trade law practitioner at Latham & Watkins, who has been recognized as International Arbitration Lawyer of the Year. Drawing on more than 2 decades of experience, Charles has successfully represented clients before the International Court of Justice, the Iran-United States Claims Tribunal, ICSID, ICC, LCIA, and ancestral arbitral tribunals. Clients praise his genuine, in-depth knowledge of international law, yet very practically minded approach and his encyclopedic understanding of sanctions regimes. Charles will address the crucial intersection of AI and confidentiality in investor-state arbitration. We are particularly proud to have Dr. Diora Ziaeva, partner and U.S. co-lead of mining and natural resources at Denton's U.S. LLP in New York, licensed in New York and Uzbekistan and fluent in 7 languages. Diora has been involved in over over 30 international arbitration proceedings worth from 10 million to 20 billion US dollars. She holds the distinction of being the first female from the Republic of Uzbekistan to graduate from Harvard Law School and serves as a Council on Foreign Relations term member, as an ICC International Court of Arbitration member and adjunct professor at Cornell Law School. She represents the bridge between our region's legal heritage and international excellence. Diora will discuss AI tools for arbitrator selection and conflict checks. I'm always proud to announce that Diora is the first Uzbek lady, as I mentioned, admitted to Harvard Law School LLP, and she holds PhD on arbitration from the Tashkent State University of Law, and we are proud of that. And finally, we have Dr. Johannes Koeb, a partner in Baker Botts International Disputes Group, recognized by Chambers UK, the Legal 500 and Global Arbitration Review as one of the leading specialists in international arbitration. Dr. Koeb was selected as one of the Global Arbitration Review's 45 under 45 most prominent arbitration practitioners worldwide. His multi-jurisdictional expertise spans energy, joint ventures, telecommunications, and financial services, with arbitrations conducted across London, Paris, Geneva, Stockholm, Hong Kong, Vienna, and Munich. As founder and chairperson of the London chapter of the German Institution of Arbitration, he brings both practical experience and academic rigor, having taught law at universities across Europe. Johannes will tackle with where the AI can level the playing field between small and large law firms. So let's begin our presentations and discussions. And I would like to provide the floor with the pleasure of inviting Carolyn Lam to address us on a lawyer's ethical obligations in using AI in international arbitration and litigation, and an arbitrator's ethical obligations in using AI in drafting arbitral awards. Carolyn, the floor is yours.
Back, I just want to make sure this is working. A pleasure to be with you and see you today and to discuss a very important topic. And I just start with a few concepts because you need to really focus on what we're talking about. I think the technological development has greatly outstripped the regulatory development. And what we see now across the globe is a real patchwork of national laws and other laws, many ethical provisions in lawyers' codes and in procedural rules that deal with artificial intelligence, but they all define it differently. And so the first step is you need to focus on exactly what they're talking about and what they're regulating. And to keep in mind throughout the discussion is that AI, however it's defined, as of today, thinks in words to the extent it thinks. It's a comparative analysis that's algorithmic. It doesn't think in concepts as humans do. And it's because of that it's not a reasoned-based analysis. It's very much mathematical, which is fabulous for analyzing huge amounts of documents, huge amounts of data. It can be tremendously important to lawyers in cases, to advocates, but under almost all arbitration rules and under most of the other rules regulating it, they do not delegate human decision-making. So you still, as an arbitrator, have to make your own decision and exercise your judgment, or you may have your award set aside. In terms of technical ability, it definitely enhances an advocate's ability. It analyzes huge numbers of contracts, but the attorney remains responsible under all the ethical codes to the client and to the arbitral panel for the quality and correctness of the information you're presenting. So even if you're doing big chronologies, you need to go back and check the accuracy of the documents and what you're going to say they reflect. You have to do due diligence on top of what the AI instrument you're using performs. There are hallucinations, so you can be maybe 80% sure that what you're saying is correct, but there's the other 20% that in fact courts have been and arbitral tribunals have been hugely critical of lawyers when they're presenting either cases that don't exist, reasoning that doesn't exist, because the AI tool gave it to them. In fact, some of the analyses are biased because of the underlying data that's in the system that you're using. So you need to understand, and a lawyer's responsibility is certainly to understand the instruments that you're using. And then I think the overarching issue that some of our other panelists will really describe at greater length is data security, privacy. Where is the data that you're using going? Your client's confidential materials, even on a firm's proprietary AI instrument, you don't know, even when you keep it confidential, whether or not that will be used to build the database, to build other things. And so you need to be extremely careful in how the data will be stored, how it will be accessible, and that's the lawyer's responsibility. Certainly, the innovation has outpaced the regulations. In Uzbekistan, we do have a new law and a presidential decree that starts the regulation of AI here. The European Union AI Act, I don't think is a model of clarity, but it does exist, and I'm sure our EU partners here can describe it with far greater accuracy than I only read it and wonder about what it means. The OECD AI principles are really quite good. And Singapore has a mass call address system that is reputedly good. I've never used it. In the US, there's no federal regulation really directed at AI. You have the privacy laws that exist. You have under the FTC, fraud, misinformation, et cetera, that would apply. You have various non-discrimination provisions, but there is not anything yet specific other than a recent President Trump executive order that orders that that AI in the US should really be predominant. The existing ethical obligations you can find in a variety of sources. The IBA has some provisions, but they're not exactly specific. The Uzbek Ethical Code has some general provisions, not AI specific, but certainly informative. Generally, it's the lawyer's obligation to understand what you're using in terms of the technology tool, to assure that your duties of competence to your client, of obedience to the client's direction, of communication, confidentiality, candor, and avoiding bias. All of those duties of the lawyer exist when you're using an AI tool and continue to exist, and it's your responsibility. So you've got to know and evaluate the instrument that you're using. There are many recent changes to the provisions in the, for instance, the AAA, the Chartered Institute of Arbitrators guidelines. I like them because they're very detailed. If you're looking at understanding exactly how to use it in a responsible way, they give you excellent guidelines on protecting the parties' procedural rights, on disclosure to all the parties in the arbitration, to including it in the first procedural order, etc., and to impartiality of the information and what you're presenting. We also have the Silicon Valley arbitration rules. They're excellent. All of them have in common the non-delegation of decision-making and the UK AI judicial guidance, which is good, but I'll leave it to my colleagues from the UK to address in depth. And court challenges as a result of using AI. The one case that everyone is watching in the Southern District of California charges an arbitral award and seeks to annul it because the sole arbitrator used AI to draft the award. I don't know if it was the whole thing or a portion of it, but ChatGPT said, no, we wrote that, and the other side challenged. It's still pending. There's a famous case, Mata from the Southern District of New York, where the lawyers used ChatGPT to draft a brief and had fake cites as a result. They've been sanctioned, and the court said explicitly, you lawyers have the gatekeeping function. So all users of arbitration have to uphold the ethical standards and the rules and the use of AI. If and how AI will be used in arbitral proceedings should be set forth transparently in a procedural order or agreed among the parties and the arbitrator at the outset of the arbitration. I think that's good practice. AI is certainly a complement to us performing our professional responsibilities, but not a replacement for our professional work. It is one of the tools that can really enhance performance and decrease cost. Party representatives should use it to deliver in a variety of ways, but they still have to take responsibility for it. And arbitrators should use AI in limited circumstances, but never to exercise decision-making powers. Thank you.
Thank you, Carolyn, for that compelling exploration of the ethical landscape surrounding AI in arbitration and also about the recent regulations. That was really very thoughtful to think about the implementation of AI and the regulations according to the ethical part, which should be also managed by the arbitrators and councils. And what do you think, how the AI tools should be used by the arbitrators, and how should this impact their duty of independence and impartiality? And maybe should there be different ethical standards for AI used by arbitrators versus councils? What do you think? Should there be one, maybe the ethical regulations, or different for arbitrators and councils?
Well, I think arbitrators should disclose if they're going to use it, both for the confidentiality issue, but also depending on what the rules of procedure say that you're under. I think it is best to disclose to the parties if you're going to use it, not just because of confidentiality, but as well in terms of bias, in terms of anything else. I like to rely on the parties' submissions and arguments. I might go to Perplexity to see if there are a couple of other cases that maybe I didn't hear about, but before I would use it, I bring it up to the parties and let them address it.
Thank you. Thank you for your opinion. And regarding the recent regulations, you provided several and mentioned about them. And can you recommend one of them as a model one to implement in Uzbekistan or use as a model to draft something here in Uzbekistan for the arbitration and litigation institutions?
You mean the rules for the Tashkent forum or for the any arbitration?
Maybe like adopting a new law with the ethical rules for the arbitrations, for the mediation centers, like for Uzbekistan, which could be adopted in Uzbekistan.
Yes, absolutely.
Maybe we can take as a model, as a best one, you can recommend one of these rules.
Yes, I think the rules, because I looked at the rules in preparation, I think both the ethical rules as well as procedural rules could be expanded to amplify the requirements to make sure there's basically a level playing field and the lawyer remains responsible for assuring the legitimacy of the evidence and the facts that they're presenting as well as the law that they're arguing to the tribunal.
Thank you. And at the end of the session, we will provide the floor for the audience to give the questions, if you don't mind, and we will go further with our next speaker. And it is my honor to invite our distinguished panelist, Andrea Pina, to share his insights with us by addressing the critical topic of AI assistance in drafting of pleadings and legal documents within arbitration. Dear Andrea, the floor is yours. Am I correct? Yes?
No PowerPoint presentation. Good afternoon, everyone. Thank you very much for the invitation. It's always a pleasure to be here in Tashkent. When the topic was determined, the first thing I've done was to use ChatGPT. I asked ChatGPT to prepare a nice PowerPoint presentation of the topic today. And this is the reason why I have nothing on the screen. The PowerPoint presentation was very good, was very nice, was very boring, was not as yours. Yours was not boring at all because it was not done by a machine, of course. But my presentation done by a machine was very boring, very descriptive, very objective. The machines are very good in repetition. They are not very good in innovation. All the pros and cons were in the PowerPoint. All the topics like hallucinations and others, all the issue was covered. But I stopped there because I said to myself that you don't need to come to Tashkent to hear what a machine has done in 60 seconds. My speech today is guaranteed 100% non-artificial intelligence generated. And I will start with an example. One client of the firm had a favorable award, principal plus interest. The principal was 100 million, but the interest was very complicated. The dispositive part of the award was very complicated. Interest since 2009 with capitalization of interest or compounded interest every year, but not on 31st December because it was so easy in the middle of the year with two different interest rates, first LIBOR and then SOFR. It was very complicated to calculate. And then a client asked me, how much is the value of the award? And I was unable to answer the question. I asked the question to two persons. I asked first to my office manager at the firm. She's very good in math. She knows how to use Excel spreadsheets very well. She made formulas. She collected all the information. It took her 3 days to know that the award valued 153 million, something. And the second person to whom I asked the question was my son, very good in math as well, and he gave me the answer in 60 seconds. And I asked him the same result, and I asked him, how did you get to the result? He said, very easy. I gave the dispositive part of the award to ChatGPT, and I got the result. And after this, I said to myself, it is very easy. Machines, artificial intelligence can do things, can maybe do everything. The topic of today is, can they replace an arbitration lawyer in drafting pleadings and other documents in arbitration proceedings? In order to answer this question, we have to ask ourselves what makes a case successful. What makes a case successful is very often not because you find a precedent that is in there. The case is successful because you have the good argument, the winning argument, because you have the good strategy, and because you have innovation. And this is, innovation is something new that has not been attempted before. And, well, I think a machine very strong in math cannot do this. And at the end of the day, why client go to, in need of an arbitration lawyer, go to see Karen Lam, not because she has a good computer. She's a superwoman. We heard this before. She's certainly not a machine. If you delegate to artificial intelligence, you will lose all this. You will lose winning argument, you will lose strategy, and you will lose innovation. And very often, the winning argument and the good strategy is not found at the inception of your arbitration case. You have to think very much before finding it. Otherwise, it would be too easy if it can be found in a few minutes. Even if you are a superwoman, you do not, maybe sometimes it takes, need some time to think. And I will give you a second example. This example is an example where I was in a panel, in a tribunal, a 3 arbitrators panel. I was a party appointed. We were deliberating. The majority of the tribunal was against me, and they came to a solution. Then the chairman of the tribunal started to draft the award himself, not with the machine, himself. And in drafting, he discovered that the deliberation was not good. He convened the arbitrators again for a new deliberation, and then the majority of the tribunal changed. I was in the minority at the beginning, I was in the majority at the end, just because when you draft, you think at the same time. If you ask a machine to draft, you will lose something. So if you use a machine to do the drafting, first of all, you reduce the quality of the defense for your client, and secondly, you reduce as well the development of the skills of the lawyers of your firm. If your lawyers do not know any longer how to draft, how to make research, how to analyze precedents, they will never improve and never get skill. An advocate is certainly a profession of knowledge. For this, artificial intelligence might be very useful, but it's above all, a profession of experience. And you can gather experience only if you do things yourself, not if a machine does it for you. It is bad, and this is my conclusion. It is bad to delegate. Artificial intelligence can be very useful and should be very useful, not to work instead of humans, but to help humans to check and to verify what human lawyers have done themselves. It's a verification tool. It's not the other way around. You cannot ask a lawyer to check and to verify if a machine is right or wrong. If you do not know how to do it yourself, how can you verify a machine? When I check my lawyer's drafting, I know I have spent many years drafting myself. So this experience helps me to control, to assess, and to comment the drafts made by others. But if machines do all the drafting, nobody can control the machines. And machines and lawyers are not alike, they are different. Like a Russian friend used to say, yuristi toje yudi. Thank you very much.
Dear Andrea, thank you for your practical perspective on AI-assisted drafting that reveals both the tremendous opportunities and genuine risks facing modern arbitration practice. And how do you think, from a practical standpoint, how do you measure the ROI of AI-assisted drafting, return of investment in AI-assisted drafting, and what metrics should law firms use to evaluate whether AI tools are genuinely improving efficiency versus just shifting costs? And maybe your opinion will be good because the AI is giving the result according to your request. And if there will be a universal prompts, instructions for AI how to write according to the arbitration requirements, and there will be provided the required data to AI, and it will provide a perfect result. In this regard, how do you think what it will be?
Thank you for the very difficult question. I will try to provide some elements for answering it, but my answer will be partial. First of all, the return on investment. I have to take two hats to describe the investment. First of all, I take off the hat of a lawyer and I use the hat of a managing partner of the firm. The return on investment of artificial intelligence is almost nil for law firms. Most of our clients ask us to build them on the base of hourly rates. If we have a machine that allows us to do things faster, we will charge less. So the investment in artificial intelligence is not very useful. For clients, it's different. Of course, for clients, it's different. At the same time, clients in arbitration proceedings want to win and do not want to spend less. That's not the primary objective. The primary objective in arbitration, most of the time, these are strategic cases for companies, for states. The financial element should be not the primary element. If you take a cheap lawyer and then you lose, it's certainly worse than spending a lot of money and win. And in arbitration cases, the amount at stake in the proceedings are much, much higher very often compared to the cost of a lawyer. So I don't think that this metric should be taken into account. Thank you.
Thank you indeed, and I think there will be more questions from the audience regarding this topic. And I would like now to invite our esteemed panelist, Charles Claypool, to share his expertise with us. He will be presenting on AI and confidentiality in investor-state arbitration. Charles, please take the floor.
Thank you very much. I'm just trying to get the slides. So I'm going to focus on one of the issues that's been discussed in the context of AI, and it's confidentiality. So I'm going to focus on the specific risks that AI creates given obligations of confidentiality that exist in international arbitration. So I'm going to start by just giving an overview of the legal and regulatory framework that governs confidentiality in investment state arbitration. I'm going to focus on investment state arbitration because there's more case law, there's more authority on it, but many of these principles would apply generally in international arbitration. I will say a few words on the tension between transparency, and there's a tend towards transparency in this area, and confidentiality. And then I'll drill down into the issues of confidentiality at different phases of the arbitration. So focusing on documents, witness evidence, and the awards themselves. And finally, I'll tie up with some of the challenges that AI pose, but I'll touch on some of those issues as we talk through them. So firstly, regarding the framework, I'll say a few words about this because there are a number of misconceptions when people talk about arbitration and confidentiality. Often it's assumed that all aspects of all arbitrations are confidential, and that's not necessarily the case. So I think generally speaking, confidentiality can be said to be determined by the agreement of the parties to the arbitration, in the investor-state context, any applicable treaties, and of course the rulings or orders of arbitral tribunals. In the context of ICSID in particular, the issue of confidentiality or publication of awards is addressed both in the convention and in the arbitration rules that basically state that the centre, the ICSID itself, shall not publish an award without the consent of the parties. And I'll come back on that. That language is generally reflected in the first procedural order. So at the bottom of this slide, you'll see wording that you'll see in the draft model first PO1, but which is often adopted, and something that may need to be amended given some of the issues that we're going to discuss. Aside ICSID, and ICSID, I think about 70 or 80% of investment state arbitrations are brought under the ICSID convention and governed by the ICSID arbitration rules. But outside that context, you've obviously got the UNDP rules. Confidentiality will generally be determined by the parties' agreement, by any applicable treaties, rulings of the arbitral tribunal, but most importantly, any applicable law, notably the law of the seat of the arbitration, a factor that won't happen in an ICSID context. Under the rules themselves, the 2021 UNDP arbitration rules specify that an award may be made public with the consent of all parties, unless, for example, there's a legal right or a legal obligation to make the award public, for example, in the context of enforcement. So basically, in the UNDP context, and then subject to some points I'll come back on, the publication or the issue of confidentiality will depend on the consent of the parties. Just touching on some of the other arbitration rules, for ICC, for example, those proceedings are not inherently confidential, subject to any law of the seat of the arbitration. Under LCIA or the SIAC rules, for example, there are specific provisions in the rules that provide for confidentiality. So the bottom line is that it's important to consider the issue of confidentiality depending on the type of arbitration you're talking about. Because as you've seen, the rules differ. And as I'll come on to, some of the jurisprudence also differs. So that's the first issue, the legal framework. Just as I mentioned before, there is an increased tendency, increased pressure towards the transparency of investor-state arbitration. It's a matter that's discussed a lot, often at conferences like that. People talk about transparency. And there's a certain amount of tension between any rules of confidentiality and any tendencies towards transparency. Transparency may be required as a matter of law, or again, the parties may agree to transparency, which will override any rules of confidentiality unless there's a specific provision to that effect. Sometimes, but I think it can be said rarely, there is specific references to an obligation of transparency in a treaty. I put an example on the screen, but I think this is something you're seeing in a lot of modern model investment treaties. There's specific obligations on the parties and the tribunal to publicize pleadings, for example. So the treaties governing the arbitration may contain transparency obligations. Separately, it's important to reference the UNCITRAL rules on transparency in treaty-based investor-state arbitration. And there, basically, the position is that there is a default that, for example, pleadings should be public, be made public, or that the hearing should be public unless the parties provide otherwise. And even if the pleadings, exhibits, etc. are to be made public, there can be exceptions to that general default position. So you've got, on the one hand, the issue of confidentiality, but also importantly, you need to consider the questions of transparency. And both of these issues will impact the extent to which documents or hearings are confidential, which will impact the extent to which you need to be careful if using AI. So drilling down into the specifics of an arbitration, the first question is, are the documents in an arbitration confidential? In particular, are documents which are produced in the document production phase, will they be confidential? One starting point is the IBA rules on the taking of evidence, which is often used as to guide the tribunal. Often in first procedural orders, the parties agree that the tribunal should be guided by these rules. And there, in the context of any documents submitted or produced in the arbitration, they specifically state that such documents should only be used in connection with the arbitration. Now, these rules have been subject to a number of decisions, and I've put a couple, or referred to a couple here. So I think one of the important early cases on this was Bywater Gulf against Tanzania. So this was investment treaty arbitration brought against Tanzania, and there was the question whether documents which could or should be put into the public domain were confidential or not. And there the tribunal specified that no restriction is appropriate upon the publication by one party of its own documents, but it stated that the tribunal considers it appropriate to restrict publication or distribution of documents that have been produced in the arbitration by the opposing party. So if you're a party to the arbitration, and this is a ICSID arbitration, and documents that you produce in the document production phase, they're, in light of that decision, which has been reflected in a more recent case against Turkey, that those documents should be confidential. Equally, in this case, this is IPEC investment against Turkey, the tribunal stated that pleadings, witness statements, and evidence produced by one party that are not otherwise in the public domain should be treated as confidential and used only in relation to the arbitration. And the tribunal said that's similarly the case in respect of minutes or transcripts, that they should only be used for purposes of the arbitration. So just tying up on documents and document production, I think that the default will be that such documents are confidential. There may be specific rulings regarding to confidentiality, there are a number of other issues, but the important point to bear in mind is that if you are counsel in an arbitration and you wish to use an AI tool, you need to be aware that particularly documents that you've received in document production are confidential, and if you feed those documents into an AI tool, you may be breaching the confidentiality of the arbitration. So that's an important point just to bear in mind in this context. Related to that is the issue of hearings. As was mentioned earlier by Carol, it may be important, may be relevant to deal with these issues up front. But in light of what I've just discussed, the transcript of a hearing will likely be confidential. That means if you want to use an AI tool, for example, to analyze 20-odd pages of transcript, you may be breaching the confidentiality of the arbitration. So in light of this, you need to be very careful when using AI tools, because some of the times when the tools might be most useful are the times when you run into biggest issues. One of the points just to bear in mind also when you're talking about hearings, it's not just the counsel to each side, but also third parties. So if you've got transcribers or stenographers in the room and they wish to use AI, they need to be cognizant of these issues as well. On the issue of I mean, this is a point that just really is an aside. In that Turkish case that I just mentioned, there was a ruling that specifically provided that one witness could provide evidence anonymously. And that might be a way to get around this. So if you do have a transcript and you are able to anonymize the transcript, that might be a solution to this. But it's something that needs to be thought about and anticipated in any arbitration. Finally, just a few words on awards. As I mentioned earlier, ICSID awards are subject, obviously, to the ICSID Convention and the ICSID arbitration rules that will generally provide that the centre itself may only publish an award with the consent of the parties, although the rules then go to specify that ICSID may publish excerpts. And for that reason, a number of ICSID awards, for example, the one you'll see on the screen, are redacted. However, that rule relates to the centre. I think there's a general conception, or perhaps a misconception, that ICSID arbitration rules, awards, are confidential. And I mean, that's not necessarily the case, and there's some legal authority out there that provides that ICSID awards are not confidential as such, and that unless the parties have specifically agreed, either party may make the award publicly available. So it's not necessarily the case that the award itself or any orders or decisions of the tribunal may be confidential, but that's something that we need to look at quite carefully. Obviously, these are important documents that you might need to use if you want to run documents through an AI tool. Finally, just on these issues, and some of these points have been raised by Carolyn, there are some institutional guidelines on the use of AI. These were referred to earlier on. I think they're of varied utility, but something that all practitioners should be aware of. It's obviously important that parties ensure that their use of AI tools is consistent with their obligations to maintain confidentiality. I mean, that's one of the most important issues in this space of AI and arbitration. Key considerations, as we've been discussing, relates to the confidentiality of information inputted into the AI tool. There may be a need, and I think there likely will be a need, for disclosure by parties and the tribunal of any AI tools they intend to use. The use of AI by the parties may be subject to tribunal approval. I mean, there are AI tools, proprietary AI tools, which are intended to be confidential, but none of us lawyers will actually understand the extent to which they are. And it may be that documents may be confidential within a law firm, but we don't really know if those documents will then be incorporated into other documents used by our colleagues, which are then published. So I think, when we're told that certain tools are confidential, we really need to understand if that is the case, and it may be that tribunals will demand us to do so. And finally, and this is not a point that I've spent any time on, but it goes without saying anything further, that tribunals need to be fully aware of all of this. Just tying on before I hand over, I think it's good practice that the issues of AI are anticipated early on in the arbitration, ideally between counsel. It probably is or will be good practice to set out parameters in the first procedural order. My personal experience is it's not current practice, but I know, Carolyn, you've got examples here, but I think it's something that will become standard practice. Before using any AI tool, it's important that counsel actually understand it and understand the limits of it, and they may need technical assistance to do so. They may need to review policies on recording, storage, the use of prompts, etc., etc. And it may be appropriate to anonymize documents before submitting them to an AI tool. So thank you very much.
Thank you, Charles. Your deep dive into confidentiality challenges in investor-state arbitration exposes perhaps the most complex intersection of AI and traditional legal practice. And we know that there's any time could occur such situation when you can recognize that the AI was used or AI tool was used during the submissions or preparation of the award, and etc. And if there is a potential confidentiality breach involving AI tools, what immediate steps should be taken, in your opinion? And how should parties notify tribunals, opposing counsel, and regulatory authorities in such situation? And maybe Carolyn, as she has a huge experience in investor-state arbitration, you can also comment on this topic. So please. Charles, your opinion?
So, I think it would depend on the specific circumstances, and this explains why this issue should be anticipated and regulated in a first procedural order. But if it is the case that a party considers that documents that have been produced in document production have been inserted into an AI or have been submitted to an AI tool, so you'd probably only learn about that after the fact, I think it would be appropriate to raise it with a tribunal. I think it would be appropriate to order that the party that has or may have done so explains exactly what it's done and what protections are in place, and then maybe take steps to implement protections to ensure that the document's confidentiality is respected going forward. But I think it's a question of finding out exactly what's going on and then taking steps as soon as possible.
Thank you. Carolyn, your opinion?
No, I agree, and I have seen under some of the rules that you actually appoint a technology expert. Oh, sorry. I've seen under some of the rules that you actually, the tribunals have appointed a technology expert to advise on what happens using the tool and how to protect using the tool. Now, I don't usually like tribunal-appointed experts, but if the parties find themselves in a situation where they haven't considered it and someone then alleges that the information has gone into a proprietary tool or other tool, the arbitrator will have to figure out what are the implications of that for that confidential information. Better to do it at the outset, but it could arise in the proceeding.
Maybe the last question regarding the investor-state arbitration. We all know about the working group 3 of UNCITRAL on ISDS reforms. And what do you think? Should these AI issues become one of the main parts of the ISDS reform in UNCITRAL discussions and the meetings?
Yes, I think they need to, and I think it's an issue that needs to be anticipated and addressed in every arbitration, given that us as practitioners are under increased pressure to use AI, and I think we will end up being in some tension between the obligations, the ethical confidentiality obligations that we're discussing, and commercial pressure coming from our clients or from our law firm to increase efficiency by using these tools. So I think we have to address it.
Thank you. I agree. I think this topic should become one of the main parts. But in this regard, I think the working group 3 will never end. So thank you. And I would now like to invite our esteemed colleague, Dr. Diora Ziyaeva, to share her expertise with us. She will be presenting on AI tools for arbitrator selection and conflict checks. Diora, please, the floor is yours.
Thank you very much, Islamberg. I think in the interest of time, I'll just make my presentation in Russian, and then I'll answer your questions in English. Добрый день, уважаемые коллеги. Сегодня я хотела поговорить на тему того, как искусственный интеллект и более широко технологии обработки данных уже трансформируют два чувствительных и стратегически важных аспекта международного арбитража. Во-первых, это выбор арбитров и проверку конфликтов интересов. То есть я не хочу вас пугать очередной футуристикой, я хотела поговорить о том, что работает уже сейчас, какие решения мы видим в практике и как сделать их частью своего, собственно, профессионального инструмента. Ну, во-первых, наверное, первая тема – это выбор арбитра и каким образом… Можно? Can I have the… Thank you. Первая тема, которую я хотела бы затронуть, это как выбрать арбитра и как искусственный интеллект помогает выбрать своего судью. То есть как это сделать, когда речь идет о десятках, а порой и сотнях кандидатах, особенно в незнакомой юрисдикции. Мы традиционно полагаемся на рекомендации, личные контакты и очень часто на свою интуицию, на чутье. Но это очень часто больше искусства, чем наука. И, естественно, в этом процессе искусственный интеллект начал играть не последнюю роль. Например, решения, которые мы видим на сегодняшний день, это различные алгоритмы профилирования. То есть существуют такие платформы, как Premonition AI, такие как GAR-Art, Arbitration Intelligence. Эти платформы, они уже стали неотъемлемыми в инструментарии ведущих фирм и институций. То есть они анализируют решения, процессуальные поведения, а также косвенные индикаторы. Например, как арбитр потенциально может реагировать на какие-то жалобы, например, продление сроков, или если дело касается, например, таких вопросов, как admissibility аргументов. Очень часто проблемы, которые мы видим, это проверка конфликта интересов. То есть, как вы знаете, случаи, когда арбитр не заявил конфликт, потому что не вспомнил или не знал, до сих пор встречаются, к сожалению. И это иногда, ну, естественно, подрывает доверие к институту арбитража. И поэтому очень часто то, что мы видим, это ситуацию, например, арбитр предоставил какую-то лекцию вместе с экспертом с противоположной стороны 3 года назад. Формально это не конфликт, но сторона может считать это иначе. Очень многие инструменты искусственного интеллекта сейчас позволяют нам находить такие тонкие связи, которые бы иначе просто либо оставались бы за кадром, либо, как вот уже отметил один из наших участников, то, что это просто занимает немного дольше времени, а это может быть сделано гораздо быстрее. И, естественно, такие примеры из практики очень полезны. Я хотела привести несколько примеров для вашего внимания. В недавнем инвестиционном арбитраже, в котором я участвовала, одна из сторон попыталась оспорить арбитра на основании того, что когда-то арбитр работал в одной фирме с юридическим советником противоположной стороны. То есть при проверке вручную такой связи выявлений не было. Но система на базе Neo 4G обнаружила, что оба были вовлечены в один проект, но в разное время, но с пересечением ключевых контактов. Отвод был отклонен, так как связи было недостаточно, но если бы сторона воспользовалась искусственным интеллектом заранее, возможно, просто бы не предложила бы этого кандидата, например. Мы также видели в 2020 году дело ЦУИС Blue Bank International против Венесуэлы, где отвод арбитра был удовлетворен из-за того, что его коллега по фирме консультировал другую сторону по делу против той же стороны. То есть сегодня такой конфликт можно было бы автоматически выявить, используя внутренние системы искусственного интеллекта, сканирующие корпоративные связи или, например, архивные документы, а также, например, те же самые совместные поездки на конференции, которые очень часто являются вопросом, насколько это действительно является причиной для того, чтобы предъявить отвод данному арбитру. Также хотелось бы поделиться рядом кейсов из моей работы как члена суда ICC, где вызовы арбитров, то есть challenges, стали достаточно серьезным вопросом. И где я предполагаю в будущем технологии на базе искусственного интеллекта могли бы изменить траекторию процесса еще до подачи позыва. То есть, например, в одном деле, где сумма иска превышала $600 миллионов, сторона подала отвод, челлендж арбитра на основании того, что его фирма в другой юрисдикции представляла материнскую компанию оппонента в транзакции 5-летней давности. То есть арбитр не раскрыл эту информацию, так как он был вовлечен напрямую и считал это несущественным. ICC суд отменил отвод, но ситуация оставила осадок и усилила напряжение достаточно в процессе. Сейчас мы видим такие системы, как Юсмунди, про которые вы, скорее всего, услышите во время форума, и их модуль Arbitrator Connections, которая потрясающая на самом деле система, она позволяет выявить именно такие опосредованные связи, даже если дело не дошло до опубликованного решения. То есть их новая платформа позволяет такой, знаете, своего рода гибридный поиск по текстам решений, то есть, естественно, публичного, который можно найти публично, по публикациям данного потенциального арбитра, по кейсам и юридическим профилям. То есть, если бы стороны пользовали такой инструмент на раннем этапе, что практически многие представители арбитражного сообщества делают, арбитр либо, например, раскрыл бы эту информацию заранее, либо был бы заменен без определенных процессуальных потерь. То есть, мне кажется, основной момент, который стоит иметь в виду, что искусственный интеллект не столько заменяет человека, а сколько помогает определить определенные моменты, которые позволяют сохранить и не иметь каких-то потерь в дальнейшем, в том числе процессуальных. В другом деле, в котором я недавно участвовала, челлендж был основан на том, что арбитр и эксперт входили в редколлегию академического журнала. В арбитражном сообществе такое встречается достаточно часто. И информация была публичной, но сторона узнала об этом лишь после начала слушания. Такие связи были иногда, например, в прошлом, я не знаю, даже те же 10-15 лет назад, практически невозможно систематически отслеживать. Например, такая платформа, как Premonition AI и аналогичные платформы, они анализируют публичную корпоративную активность участников арбитража, например, совместное участие в каких-то комитетах, соавторство публикаций, упоминания в академических мероприятиях. И что интересно про Premonition, то что его характер этой платформы, он предиктивный, то есть он может показать нас не только связи, но и тенденции поведения арбитра на основе статистики решений, если она не, предположим, доступна в публичном space. Хотя арбитражные данные менее открыты, чем судебные, как мы знаем, некоторые платформы уже строят модели на базе публичных арбитражных решений по челленджам и даже устным аргументам в некоторых институтах. Наверное, один из наиболее чувствительных случаев, рассмотренных наверное, в последнее время, касался арбитра, который 4 раза за последние 6 лет назначался одной и той же стороной через разные аффилированные фирмы. То есть на момент вызова эта информация была частично известна, но не имела полной хронологии. То есть сейчас, например, тот же самый Юсмунди с интерпретацией, например, в ICC, это будет ICC Case Connect, может показать все публично доступные назначения арбитров, включая повторы юрисдикции, тип дел и связь с фирмами. То есть технологический вывод, который стоит отметить, и мы это обсуждали при подготовке сегодняшней панели, это то, что случаи становятся гораздо более прозрачными, что дает возможность участникам арбитража действительно как бы знать, иметь какие-то конкретные ожидания. То есть искусственный интеллект — это не только как бы про технологии, это предупреждение сложностей, с которыми, например, можно столкнуться при назначении арбитра или на стадии challenge. Ну, естественно, со всем этим моментом есть еще определенные риски. Но, во-первых, существуют ошибки алгоритмов, про которые мы слышим очень часто. То есть искусственный интеллект не всегда отличает этого. Он может соединить не тех людей, особенно, например, в странах с распространенными фамилиями. Это встречается и об этом говорят. Например, есть определенные этнические ограничения. То есть в некоторых юрисдикциях автоматическая обработка персональных данных для оценки независимости может считаться нарушением. Еще один риск, который достаточно часто упоминается, это опасность избыточного доверия. То есть клиенты иногда принимают результаты как окончательный приговор, о чем говорил господин Пенни, то, что на самом деле мы как профессионально не можем на это ссылаться полностью, и мы, естественно, должны понять, что искусственный интеллект — это помощник, а ни в коем случае не решающее лицо. То есть, наверное, вопрос заключается, в заключение хотела бы сказать, что вопрос основной, с которым я столкнулась, анализируя и готовлясь эту презентацию, это, наверное, вопрос, который представлен в титуле этой панели. То есть как мы дойдем до баланса. То есть искусственный интеллект уже меняет подход к выбору арбитров и проверке конфликтов. То есть не заменить человека, но обязательно усилить его суждение, ускорить анализ, расширить охват. И, наверное, возвращаясь к теме challenges, которая самая актуальная в теме вот именно выбора арбитра и conflict check, это то, что, конечно, искусственный интеллект — это не anti-challenge sheet, это способ минимизировать, наверное, процессуальные риски, которые, как мы знаем, могут стоить очень дорого. Не только финансово, но и для восприятия арбитража как справедливого и независимого процесса. Поэтому, наверное, искусственный интеллект, очень часто говорят, это не как костыль, а как оптический прицел, чтобы видеть дальше, точнее и шире. И напоследок, если в следующем деле вы сомневаетесь, скажем так, между кандидатами, доверьте, конечно же, финальную проверку не только коллегам и своему опыту, но также объедините это с тем, что могут предоставить достаточно хорошие и качественные платформы и машины. Они, естественно, не заменят то, что сделает юрист, но однозначно поможет. Исламбек.
Большое спасибо. Я бы, наверное, хотел... Да, аплодируем. Юрий. Я бы, наверное, хотел задать вопрос, уточняющий для вас с точки зрения, на каких источниках должен базироваться искусственный интеллект для того, чтобы выбирать арбитра, и как гарантировать то, что эти источники информации являются правильными, действующими, то есть не устаревшими и достаточно обоснованными или достаточными для того, чтобы эта система искусственного интеллекта предоставила действительно хорошую, правильную, достойную информацию по выбору арбитра?
Вы знаете, Исламбек, на самом деле это очень хороший вопрос. На мой взгляд, ответ, который мы можем дать сегодня, он может абсолютно быть неактуальным даже через год, потому что системы улучшаются, они меняются, появляется лучшая платформа. Очень многие фирмы создают свои собственные базы данных, и, естественно, это помогает с очень важным моментом, который госпожа Лэм уже отметила, касательно конфиденциальности, что очень-очень важно. На мой взгляд, естественно, на данном этапе любую информацию, которую вы получаете из платформ, которые я указала, эту информацию необходимо проверить, на нее невозможно 100% ссылаться, это однозначно. То есть это, наверное, первоначальный такой драфт, который, может быть, вам позволит увидеть какую-то информацию для дальнейшего использования. Но, например, Юсмунти, как я уже сказала, это действительно они работают над этим достаточно долго, и очень многие в практике используют хотя бы для первоначального conflict check возможность того, что если мы, например, рассматриваем кандидатуру такого-то арбитра, что может подсказать нам, например, платформа YouSmoothie. То есть на данном этапе, на мой взгляд, как бы in first instance, это достаточно популярная платформа для первого, для first check.
Спасибо большое, Теора. У нас остается не очень много времени, поэтому мы, наверное, перейдем к последнему нашему докладчику, и после этого мы дадим возможность аудитории задать ваши вопросы. Now I have a pleasure of inviting our esteemed panelist, Johannes Kopp. Oh, yes, Johannes Kopp, to share his insights with us by addressing the interesting topic as a question. Do you think AI or AGI has the potential to level the playing field between small and large law firms? Johanna, please, the floor is yours.
Thank you very much. Perfect. It's already my second time in Tashkent this year, and I have to say I'm truly happy to be here and honored for the opportunity to speak on this distinguished panel. So over the next 7 minutes or so, I'm going to address this question of whether modern, powerful AI tools may help to level the playing field between small and big law firms in our field. Now, I thought it would be a good starting point to look at how we at Baker Botts, at my firm, have integrated AI into our international arbitration practice so far. So we are currently using different platforms. First of all, a specialized AI tool for the legal sector called Harvey, which is a kind of contained system. So the documents that we can upload on this platform are not shared on the internet to address issues of or concerns of confidentiality. Then we use a bespoke document review platform. We have an AI-powered translation service, and finally an AI tool for international law and arbitration research. On the current slide, you can see some of the practical examples of how we are using AI. First, imagine you have just been hired for a new case, or you need to prepare for a pitch, and you want to find out about your new client, a new industry sector, or a country that you're not familiar with. Then tools like Harvey actually can provide you with very well-resourced, valuable information as a starting point. Secondly, AI tools can be very useful resources and to catalog large volumes of documents. Again, a practical example, in an arbitration, our opponents recently dropped a large volume of unorganized documents on us, which we had to review within a very short period of time. And then Harvey allowed us to organize these documents into categories according to the type of documents and the topics which the documents addressed. Thirdly, AI tools can help you to quickly obtain an initial analysis of how a voluminous contract addresses a specific question. Or another practical example, on a late Friday afternoon, I was asked by a client to summarize the status of settlement negotiations that had occurred over 18 months or so. And rather than asking an associate to do this task, I uploaded the relevant documents on this Harvey platform and got a summary, which of course I had to check, etc., but a summary within seconds. Next, translations. And I think, to my mind here, the progress has been really breathtaking. And I'm finding this extremely valuable when interacting with local counsel on multi-jurisdictional disputes. With regard to hearing prep, AI tools should be able to assist you to get ready for trial with regard to witness prep, initial outlines for cross-examinations, etc. AI tools are very useful with regard to the review and analysis of hearing transcripts, or in terms of providing initial drafts of dramatis personae or timelines. As regards legal research, in contrast, I think AI at this stage is only useful for some very basic initial research. To get a precise, reliable answer to a complex question of law, I found it rather useless. The same for strategy. You don't find the answers to complex strategic or technical questions arising in difficult arbitration proceedings using ChatGPT or different similar tools. Now, what are the opportunities for smaller law firms arising from these technological developments? First, as to document review, thanks to AI, smaller law firms can now do more, if not all, of the work in-house without needing large teams or having to outsource this work. The next 2 points on this slide are linked. Before AI, we oftentimes used rather large teams of young lawyers to research legal questions arising under different laws, which placed big international law firms at a considerable advantage. Now AI allows you to do the same type of research quickly and efficiently within a couple of prompts, albeit with the severe limitations in terms of reliability and the resulting need to check the results carefully. Again, the next 2 points are linked. Because many more mundane tasks can be automated, capable lawyers at smaller firms can focus on higher value activities rather than producing timelines, slide decks, or conducting basic research. The advantages that AI offers in terms of selecting arbitrators have just been discussed, and I won't go into the details of that. But there's also a severe limitation in that a lot of this information, the relevant information, is not in the public domain and therefore also not accessible through AI, both as regards personal and professional relationships, past work, preferences, leanings, etc. Larger firms in this regard retain a very significant advantage due to their institutional knowledge. And that leads me to the risks and limitations for smaller firms. The first 2 points on this slide are again related. Small firms may be able to operate more efficiently thanks to AI, but in major, bet the company or politically sensitive disputes, cost pressures are less relevant. In such cases, states or big corporations don't go for the cheapest, but for what they perceive to be the best option. Counsel associated with big law firms that have been active in this field for decades have an incredible institutional knowledge that you don't find on the internet. Being associated with a big international law firm, therefore, still gives you as counsel instant credibility with the decision makers. I don't think that AI will change that. This doesn't mean that big law has a monopoly on such disputes. Many big US law firms, for example, no longer consider international arbitration to be sufficiently profitable compared to, for example, private equity work. And as a result, they get rid of their international arbitration teams. The result is an increasing number of highly specialized arbitration boutiques with very experienced arbitration practitioners that are able to compete with big law for the most interesting and most complex cases. As to costs, that's the next 2 points on the slide. When preparing for this presentation today, I thought this was a real problem for smaller firms. But interviewing peers at some of the successful arbitration boutiques didn't confirm this concern. So I now think that the costs associated with introducing AI is rather a problem for sole practitioners or very small firms. I recently, for example, had an arbitration-related court proceeding in a European jurisdiction, co-counseling with a very small boutique with only 3 or 4 attorneys, headed by a very senior partner nearing retirement. Will such firms really make the financial investment? Are such senior practitioners prepared to reinvent themselves and get used to the new ways heralded by artificial intelligence? And if they don't, are they doomed? Next, as AI already can perform many of the tasks that used to be done by trainees or young lawyers, the question arises, who is going to pay for the training of young lawyers going forward? And again, I think this puts small firms at a disadvantage because large firms are in a better position to absorb those costs and invest into the stars of the next generation. The last point on this slide, I assume most of you are familiar with the problem of confirmation bias in the selection of arbitrators, even without AI. This bias can lead to a narrow pool of potential arbitrators and a lack of diversity. Many AI systems are designed to personalize information based on a user's past behavior, preferences, and interactions. This may, over time, reinforce and deepen confirmation bias. When it comes to the selection of arbitrators or law firms handling the very interesting cases, that might lead to a further concentration of power in the few chosen arbitrators or few chosen law firms. And this already leads me to my conclusions. I obviously don't have a a crystal ball, and it's difficult to predict the competitive landscape in circumstances where no one really knows how our profession will look like in 5 or 10 years, given how rapidly the technology is advancing. With the exception of a handful of specialized arbitration boutiques, I don't see that even with AI, small law firms will be able to compete for the major bet the company billion US dollar disputes. Query whether the very small, at the other side of the spectrum, whether the very small, straightforward disputes, which involve clear facts or clear contractual terms, will ultimately in the future be resolved through automatic decision-making. The biggest opportunities for small law firms, therefore, will likely arise, to my mind, in the middle range, the $1 to $50 million range. On balance, I can see how AI may help smaller law firms to get a bigger share of this pie in the future. Thank you.
Thank you indeed. And I think there's one question for you, which could be an interest for the young lawyers. What do you think? What new skills should arbitration lawyers develop to remain competitive in an AI-enhanced environment?
That's a very interesting question. My son intends to read law, and I'm really worried about the impact of AI on our profession. So I've told him, you will not be replaced by AI, but you will be replaced by a lawyer who uses AI. So I think it's absolutely essential that young lawyers familiarize themselves with these techniques. And for example, in my team, we have the systems that I mentioned at the outset. I've rolled out them to the whole team, and every team member is using them. So I think it's absolutely essential that you get used to working with these programs.
Thank you indeed. And I think we have all the presentations and the time limits are over, but we are going to give the possibility to the audience to give the questions. Please, if there's a questions, give a short questions and we will try to answer. So please, there is one question in the middle of the, yes, please. And please, could you provide the microphone? We have the microphone for you.
Can you hear me? Yeah, thank you. Well, good afternoon, ladies and gentlemen. My name is Akmal Janesho. I'm the student at the Westminster International University. And my question would be, how do you balance the potential cost savings from AI-enhanced efficiency against concerns about confidentiality and data security? Thanks for your response.
Would you like that the answer will be repeated, or the panelists would like to answer? Who would like to answer? Begin. Caroline, you want?
Well, as I understand it, and I don't know if I have it right, it's a balance of the cost versus confidentiality and bias. I don't know that that's a good equation. You're not going to risk violating client confidences or using a biased instrument to save some costs. I think you can save about 25 to 30% in terms of costs if you use AI appropriately, but it takes a lot to check the output. And I will say, in checking the arbitrator backgrounds, I've used the various instruments, and at times you get 10 pages of purported conflicts and experience. By the time you have someone go through it and check it, you come down to 2. So you can't rely on the output that you get, particularly on that, because I think a lot of it is hallucinated.
Thank you. Any other opinions? Please, Andrea.
Yes, if I may, there is something else to put on the balance as well. And this something else is the risk, the damage you can suffer and that your case can suffer. We had heard a few minutes ago that IA is very good in examining a big volume of documents, big volume of exhibits. But sometimes there is just one document which we call the smoking gun. And if experienced lawyer does not go through millions of pages of documents, will never find the smoking gun. And I bet the artificial intelligence will not find it. So sometimes you spend a lot of money for nothing, but sometimes you spend a lot of money and time for one-page smoking gun. And I think on balance is sometimes very useful because you can win a case like that.
Thank you. And yes, please.
Just one comment on what Andrea just said on document production or on the fallibility of AI tools. The same is true for human beings, of course. And when you think about a document review, what is more likely, that a computer will miss the smoking gun or a tired paralegal who's already worked 16 hours?
I totally agree with you, and this is the reason why a document should not only be read and analyzed by a paralegal. The way after 30 years of experience, I can read a letter, and the way a junior paralegal reads the letter is not the same.
Thank you.
But
Caroline, please.
I think what AI can do in that example is give you a chronology, and you can see a segment of time where there's a lot of activity, and you know you've got to read that. If you still have no smoking gun, you might have to read more.
Thank you. And any other questions from the
yes,
audience?
I can add just one thing.
Please, Andrea.
On one case, but Karen is very aware of this case, we found the smoking gun, but we find it 10 years later because it was processed by computer before, and the document, which was a smoking gun, a real one, was put in the wrong category.
Thank you. And in the first, please, your question.
Thank you for your presentations, especially Andrea's presentation was really colorful. Thank you. And one thing I wanted to know, we heard from you, dear speakers, the point about weakness of AI, but we never heard about weakness of AI in legal research to be considered, okay? But we never heard about professional prompts. Have you tried to use any professional prompts to get more correct or more effective answers from AI in legal research?
Can you clarify the question?
Yeah. Professional prompts is the kind of prompts that specialize to get the more effective answer from AI. Sometimes professional prompt can be longer than the result of the same, the result to the question. Yeah.
I think he would like to ask that we can prepare a special prompt, like instruction for the AI, which the AI will use during the preparation of the answer or analyze, etc. And if you will prepare a very good instruction, like a prompt, like a universal prompt for something, the AI will provide a very good result each time when you do the same thing, like research or drafting or etc. So,
Exactly.
And the question is,
have you ever tried this kind of professional prompts?
I have tried. Have you tried to use such a prompt in your practical cases? That was the question, as I understand. Thank you. So, any answers?
So I have used several prompts in a line, and the results get better and better. But the problem, at least with legal research, what I've seen is oftentimes the cases are not correctly cited, or they put quotes in quotation mark, and when you then go to the actual cases, you see that it's not the actual quote. So this has, to my it undermines confidence in the reliability of these tools. And I think, at least in my practice, I use them, but then I always go to the textbooks and the cases to see whether the results are actually accurate.
No, not always. Yes, it depends which AI tool you are using. And I have used I have prepared with AI the professional and universal prompts for the translation of the legal documents and legal texts. And this prompt works perfectly. And you can do this, but it depends how detailed and accurate prompt you will prepare, which AI system you are using for that, and your instructions to AI. That always depends on the result of the AI which will give it to you. So it is on your hands. Any other? Oh, so there's 2 questions, and I think then after that we will conclude. I'm sorry because we do not have much time. So please, 2 questions. The microphone, because we need the translations. No, for others.
Thanks for having an opportunity to ask a question. So let me introduce myself. I am the student of Tashkent State University of Law, and my question is addressed to the Mrs. Caroline Lim. Caroline Lim, Lam. So what are your thoughts on arbitrators using AI tools in drafting awards? And will these AI tools will provide fairness and justice in arbitration awards?
Well, as I mentioned, you would have to tell the parties in advance that you intended to use AI tools, because you can't be putting their evidence, their arguments into the tool without their consent. And I think that functionally, the arbitrator might use an AI tool to summarize the witness statements or to summarize the contracts or some part, the timeline. But I think at the end of the day, what you want and what you've contracted for basically is the arbitrator's judgment. You need the arbitrator to read the evidence and understand it, read the law and understand it, and come to a conclusion, having given the parties the opportunity to address the issues.
Andrea, you want to comment, please?
Yes. On this, what I've witnessed in my experience in my professional life is that often arbitrators are willing to use artificial intelligence, and at the stage of the drafting of the terms of reference or the terms of appointment, they propose a clause to the party, a stipulation according to which they will precisely disclose the use of artificial intelligence tools. And very often, parties revert to the arbitrator saying, we prohibit the use of artificial intelligence, because everyone is very afraid of it.
Thank you. So the last question, and we will conclude.
Assalamu alaikum. Thank you for giving information, useful information. So I have a question. It's very interesting for me. As arbitrators, what do you think about lawyers using AI during the case? Should the rules for telling you about AI use be different when they use AI for write witness statement rather than legal research? Thank you for giving answer.
So anyone would like to answer? Or
well, in AI to write a witness statement, I mean, many times you have an AI tool on when you're interviewing a witness to make the summary, but then the drafting of the witness statement really has to be, in my view, collaborative with the witness. After they see the written product, they have to go over line by line, as well as looking at document by document that you're going to use to support that statement. I don't think you can just have AI draft it.
I also think we shouldn't underestimate the importance of the human element. It's for me a little bit like, you know, you could go to the best restaurant in the world, but if the meal was cooked by a robot and you would be served by a robot, I wouldn't find this particularly attractive. And I think also from the arbitrator's perspective, it's pretty obvious when parties use AI. And if, you know, if it's this, I believe arbitrators also would like to be convinced by human beings and by specific, authentic advocacy styles rather than a perfect computer-generated work product. So I think regardless of the ethical obligations, it's also, I think, a question of efficiency of the advocacy.
Thank you. And before the concluding of our session, I would like to ask each panelist to give a short suggestion or recommendation to Uzbekistan on the developing the legislation, rules, and the practice with the implementation of AI to the ADR system of Uzbekistan. So please, just maybe one short suggestion or recommendation to Uzbekistan. Caroline, would you like to begin?
Well, I do think the most important thing is the preservation of the due process. You can't have a system that simply takes it out of the hands of the parties or the arbitrators.
Thank you. Andrea?
Thank you very much. It is not prepared, but I think you should continue to do what you are doing at the university, focus more on real intelligence rather than artificial one.
Thank you. So then we are going to Charles.
I think you need to just remember that artificial intelligence is one of many tools that are at the disposal of human beings. And I think you need to really identify where there are problems, if there are problems, or what problems they are before you start regulating the whole construct.
Thank you. Diora?
I would say most importantly is, I guess, two things. One, I would probably definitely be very attentive to everything that's happening in every jurisdiction and international area, all the developments, and try to see what actually works, what doesn't, so keep track. But I also would say be very cautious because the margin of error is really high. So that the key is truly not to be too fast, really. So be cautious, but keep track.
Thank you. Johannes?
I also think it's a real game changer, and I wouldn't worry too much about the young generation because they grow up with this technology. So my recommendation would be encourage also the older folks, people like me, older than 50, to take up this new technology and become the most advanced country in this region when it comes to the use of AI.
Thank you indeed, and I think we can conclude, and I would like to mention that AI is not coming to arbitration. It has already arrived. The question is not whether to embrace it, but how to do so responsibly and effectively. The future of arbitration will not be defined by artificial intelligence defeating human practitioners, but by intelligent humans leveraging artificial intelligence to serve justice more effectively, efficiently, and equitably than ever before. Using this opportunity, I would like to thank all our distinguished panelists for your speeches, for your presentations and insights, and all the expertise you provided. I think our panel was very productive and fruitful and gave a lot of new information and ideas for future lawyers and for the future practice using AI. I would like also to thank the audience for your participation, for your questions. Thank you very much, and thank you, and I would like to thank our translators for their work and giving their time to translate carefully our speech. Thank you very much, and I would like to mention that today in the evening at 6:30 we have a dinner at Alisher Navoy Theater. So thank you indeed to everyone for your participation. So see you in the next session, next part, after several minutes, and we still have several minutes for the coffee break. Thank you indeed. And for the panelists, let's have a photo.
I am representing Tashkent International Arbitration Center, or TIAC, one of the leading arbitral institutions in the region that serves as a platform to resolve and avoid disputes efficiently and effectively. Among non-confidential parties that have already referred their disputes to TIAC are a Korean company involved in infrastructure projects, Tech Cross Water and Energy, Czech company ISB Genetic, and American company Crossover Healthcare Fund LLC. Users in their feedback highlight TIAC's exceptional responsiveness, efficiency, transparent procedures, as well as modern rules as key reasons for choosing TIAC to administer their disputes. We welcome everyone to witness what promises to be a remarkable discussion today on artificial intelligence and arbitration. In my capacity as the moderator, I relish this opportunity to host and moderate this discussion and share the stage with such distinguished speakers. We're deeply grateful to the Ministry of Justice of the Republic of Uzbekistan, His Excellency Minister Akbar Tashkulov, as well as all the team at the Ministry of Justice for the impeccable organization of this significant legal forum. In the interest of brevity and for us to jump to the discussion as quickly as possible, I would like to very briefly introduce the audience to our stellar panelists. Dr. Suleiman Boscha, on the left, is a chairman of the Energy Disputes Arbitration Center. Dr. Boscha is also the founder and managing partner of Boscha Law Firm. Among other professional activities, he is the chairman of the Energy Law Research Institute and a member of the Turkish National Committee of the World Energy Council. Next to Dr. Boscha is Gloria Lim. Gloria Lim is the CEO of the Singapore International Arbitration Center. Gloria also heads the Singapore delegation involved in the Ancestral Working Group 2 discussions. Next to Gloria, we have Arjun Sivaprakasam, who is the Director of Government Relations, Asia and MENA at Uzmundi. We have been hearing a lot of references to Uzmundi today. And last but not least, Ulrich Kapetsky. Ulrich is an Austrian lawyer and the acting director of arbitration and ADR, Europe and Central Asia of the ICC Dispute Resolution Services. Dr. Boscha, I'm pleased to give the floor first to you, and I understand that you will be speaking on the evolving role of humans and artificial intelligence in decision-making processes, particularly within the context of arbitration. The floor is yours.
Thank you, Chairman. Before I begin, let me say how truly grateful I am to be here. Thank you to the organizers of the Tashkent Law Spring for creating this incredible space where legal minds from around the world can come together to reflect, challenge, and innovate. Let me begin with a true story. A story that didn't come from fiction, but from a federal courtroom in Manhattan. In a routine lawsuit, a passenger sued an airline claiming he was injured when a metal-serving car struck his knee during the international flight. The airline moved to dismiss the case, arguing that it was time-barred. The passenger's attorneys responded with a written opposition brief. It looked proper. It cited over 6 federal appellate cases with names like Martinez versus Delta, and Varghese versus China Southern Airlines. But something wasn't right. The opposing counsel couldn't find the cases. The judge searched legal databases, nothing. One by one, every cited case was revealed by the completely fabricated. The court asked the attorneys to produce the decisions. What came back were AI-generated summarizes with fake citations, fake quotes, even fake panels of judges. It turned out the lawyer who had drafted the brief used ChatGPT to find supportive case law. He had even asked the AI whether the cases were real. It replied yes. He believed it. The brief was signed and filed by a colleague who had not verified the content. When questioned by the judge, the attorneys initially said one of them had been on vacation. Later, it was revealed this wasn't true. The delay was meant to cover for the AI-generated error. In June 2023, the court issued a $5,000 sanction. The judge ordered the attorneys to send a copy of the ruling to every real-life judge whose name appeared in the fabricated citations. He chose not to compel an apology because, as he wrote, a compelled apology is not a sincere apology. In his written opinion, he was direct. Many harms flow from the submission of fake opinions. The opposing party wastes time and money. The court's time is diverted from other important work. The act promotes cynicism about the legal profession, and the future litigant might refuse to obey a ruling claiming it could also be fake. Disciplinary referral was not ordered, but the case became a first ever AI-related judicial sanction in the US legal system. Legal ethics scholars describe the outcome as a public warning, not just to these lawyers, but to all legal professionals who rely on technology without verification. This was not a high-profile commercial dispute. It was a simple personal injury claim, and yet it triggered a global conversation about artificial intelligence in legal practice, because it showed just how easy it is to cross the line between assistance and abdication. When we stop checking what we submit, when we start trusting machines more than our own judgment, we are not longer just using technology. We are surrendering responsibility. Yes, artificial intelligence has entered arbitration boldly. It reviews documents, it translates arguments, it suggests language, it summarizes law, and it does it fast. AI tools organize case files, detect inconsistencies, and assist with procedural management. They save time, they reduce cost, they improve access. Yes, AI can make arbitration more efficient, but speed is not the same as justice. So where is the risk? The risk lies in what AI cannot understand. AI doesn't know values. It doesn't understand fairness, confidentiality, transparency, or responsibility. It only processes data. It does not reason, and it does not care. Let's begin with confidentiality. In arbitration, confidentiality is essential. It protects sensitive business and financial information. But if you pass a confidential clause into a public AI tool, like ChatGPT, that information may be stored or reused in the future responses. The CR 2025 guideline is clear. Know your tool you are using. Check its terms. Avoid platforms that store or reuse user data. Where possible, use close to secure systems. Now, let's talk about transparency. Parties have a right to understand how a decision is made, but many AI tools, especially large language models, work like black boxes. We don't know how they reach their conclusions, and what is the serious problem in dispute resolution. CR strongly warns against using AI outputs that cannot be explained or verified. Finally, let's turn to responsibility. This is where the line must be drawn. AI can help, but it cannot decide. The arbitrator, the council, the institution, they remain responsible. No matter how advanced the tool, human judgment must stay in control. That's why CR emphasizes the human-in-the-loop principle. If you use AI, you must supervise it, and you must take responsibility for the outcome. So, how should we use AI? Where do we draw the boundaries? CR provides 4 clear and practical principles. First, responsibility cannot be delegated. AI may generate a draft or suggest legal content, but the user, the lawyer, the arbitrator is responsible for checking it. You must confirm the content is correct, relevant, and lawful. The AI says so is not a defense. Second, transparency is mandatory. If AI is used in submissions, analysis, or drafting, it must be disclosed. The other party and the tribunal have a right to know. That is part of due process. Justice must be open, not hidden behind code. Third, technology should not create inequality. If one party has advanced AI tools and the other does not, there is a risk of unfair advantage. Tribunals and institutions must monitor this. Equality of arms applies not only to legal arguments, but also to the tools used to present them. Fourth, legal and ethical standards still apply. AI must follow the law. They must comply with data protection rules, institutional guidelines, and professional ethics. If a tool violates these standards, even indirectly, it should not be used. Technology must serve the law. It must never bypass it. These 4 principles remind us of something important. AI can support arbitration, but it cannot replace human responsibility. The final judgments still belong to us. Yeah, what about Turkey? And let's look at how Turkey is approaching AI injustice. Turkey is not moving fast, but it is moving with intention. The National AI Strategy, issued by the Minister of Industry and Technology, identifies the justice system a priority area. This strategy proposes using AI in court processes. It mentions plans to improve platforms like UYAP, Turkey's National Judiciary Informatics System, but these are strategic goals, not yet operational systems. There is currently no official AI used in judicial decisions in Turkey. And in arbitration, no Turkish arbitral institution has yet integrated AI into its case management or decision-making process. At IDAC, we are actively exploring this potential, and soon we hope to share our developments with the arbitration community. Meanwhile, some Turkish law firms use AI in limited ways for document organization, translation, or summarizes. But these uses support workflow. They do not affect legal reasoning or decision. So, in the end, AI may assist, but humans still decide. Because justice, true justice, is not about speed. It's not about understanding. It's about weighing arguments. It's about doing what is right, even when it's difficult. And that is something no machine, no matter how advanced, can truly do. Law is not just a system of rules. It is a system of values. And upholding those values takes courage. That courage still and always belongs to us. Thank you.
Thank you so much, Dr. Boscha, for your insightful contributions. We'll get back to you with some questions at the end. And I would like to pass the floor to Gloria. We are delighted to have you as our stellar panelist. And we all know that SIAC is among the top arbitral institutions in the world. And we would like to learn more about SIAC's digitalization initiatives and how SEAC has integrated it into its case management and institutional policies. The floor is yours.
Thank you so much, Diana. Real privilege to be here today to share some of SIAC's experience and some of our views about how AI is integrating with the arbitration process. I have 4 slides, so I will use these slides to guide our discussion today. So one of the key value propositions of arbitration is its flexibility. And so in SIAC's rules, we have provided for flexible use of digital tools. And this includes AI in arbitral proceedings. The arbitrator is free to discuss with the parties the potential use of AI. That said, in our rules, we have also recognized that with use of more digital tools, use of AI, there is an attendant need for more information security. So for that reason, in our new rules, which just came into effect this year, we have a rule that emphasizes the importance of information security and allows the tribunal to discuss information security measures with the parties and also to give the arbitrator the powers to direct and order or award for sanctions, damages, or costs if security measures that were directed by the tribunal are not adhered to. We have also moved to digitize arbitration because of the convenience that it brings. We serve users from more than 100 jurisdictions over the past 5 years. And for that reason, you will see that there's a wide range of needs that have come up in the arbitration proceedings, and different parties may want different solutions. For that purpose, we have a case management system that is flexible. We can do e-filing, online payment, in-system document storage and upload. And there's also the ability to provide real-time case tracking and case management through the digital interface. That said, use of this system is not mandatory because there are parties who might prefer just the simple email to us. And last but not least, we also pursued certification for info security, and this is to ensure our systems are in place to protect data and system integrity. I turn now to potential applications of AI in arbitration. And as the slide suggests, this is really a work in progress. Throughout the day, we have heard about AI, but we have also heard about the limitations of AI. So in this slide, I put forward some of the potential areas of AI application which are viable and can be explored. In the area of case management, we can see AI creating more efficiencies for arbitration. For example, in supporting the drafting of standard letters, deadlines tracking, procedural history checking, interpretation and transcription of hearings, for example. We see uses of AI in the selection of arbitrator. For example, filtering arbitrators based on their expertise and availability, identifying potential conflicts. We also see some uses for AI in the context of scrutiny of an award, which is something that SIAC as an institution does, and that I think ICC also does scrutiny of awards. This is a process where we check the award to ensure that it complies with New York Convention requirements, and if there are substantive matters that require further look, the tribunal has some help from the Secretariat to point these out. So in the area of scrutiny, we see that there is value for AI to support conducting first-cut reviews of, say, the procedural history in the award, trying to spot inconsistencies, and conducting compliance checks. We also see use for AI in the area of translation, right? Even here we have two or three languages operating, and we have translators helping. In the context of arbitration, sometimes it is useful to have aides to do quick translation to aid the understanding of the parties and everyone in the arbitration proceeding. And so translation is one use where AI would be relevant. That said, I've named quite a few potential uses of AI, and there are definitely many other uses. But I think what is important is the principles that undergird the use of AI and how AI is deployed. These include considerations of fairness to both sides, confidentiality, as has been discussed in the panels before us, due process, and accuracy of what the AI is producing. I turn now to some of the key considerations that we have taken into account where we look at integrating AI solutions with arbitration. The first, of course, is confidentiality. One of the dangers that was outlined in the earlier panel was that AI tools operate across multiple platforms and may not always be very transparent about how the data is processed or stored. So when we use AI, we need to be mindful of how to design the system so that confidentiality is not breached. There is need to consider impartiality and due process. There's often a risk of algorithmic bias due to the selection of the data set, as well as the training methods for the AI. The AI is, in the end, as good as the data that it is fed. So there will be issues, for example, of lack of cognitive discernment. The AI will not have the ability, unless correctly instructed, to weigh relevance and materiality. There may be affirmation bias concerns. There may be bias in the output of the AI-produced result. And so the data that is fed to the AI also needs to be looked at. There's also cognitive inertia. If the user, for example, the arbitrator or the lawyers, are very trusting of the AI and do not check what the AI produces. There's also a need for proper reasoning and decision-making. And AI sometimes, we have all heard about the hallucinations and the black box issue. And so AI has still not developed to the state where we can fully trust the output. There is also practical issues of enforceability due to different regulations and public policy positions on the use of AI across jurisdictions. And last but not least, there's the issue of proportionality. The use of AI should remain proportionate to the value, complexity, and nature of the dispute. So, for example, perhaps AI-generated decision-making could be more suitable for high-volume, low-value types of disputes compared to a dispute that is of high complexity and high stakes. So I go on to the last slide, which just talks about the roles of arbitrators, practitioners in an AI-enabled ecosystem. To save time, I have it out in a table form, and so I will not go through every box in the table. But essentially, AI is a tool that can complement the arbitration process. And you can see from the first row that whether it is the arbitrator, the institution, the counsels involved, or the experts involved, AI can complement their job by supporting legal research, assisting with the case management, automating, reviewing, supporting research and analysis, and also processing data sets. But what remains irreplaceably human is the need to assess, to apply fairness, to make contextual decisions, to have a strategy that may not be based on the past, but based on what you see on the case at hand, and also interpretive judgment. And so the conclusion is that AI and arbitration can coexist. There's an integration that is needed, but for the users of AI, there's really a need to upskill. AI literacy, learning prompt engineering, and verification will be essential for professionals in the arbitration field, so that when you use AI, there's responsible use and informed use of AI in the process that will augment the results for the users of arbitration. Thank you.
Thank you so much, Gloria, for your insights and very relevant institutional angle into this discussion. Arjun, we've heard so many references to Jus Mundi today, and this is why I think this is particularly interesting to hear another perspective into the matter from trailblazers like you. We know that Jus Mundi is one of the first and one of the most prominent legal technology companies. So tell us how AI is reshaping the field that we're all in.
Yes, thank you. So just a very short introduction about me. This is Arjun from Jus Mundi, and Jus Mundi is a legal tech platform specially custom-made for international arbitration. So here I am today to explain how legal tech platforms such as Jus Mundi or other platforms can augment, can improve the efficiency, productivity in international arbitration. So a very short agenda. I'll tell you about the context, what are the problems that we are trying to address, what are the current existing problems, and why AI matters, and a very short show on like how the tool works as well. From the morning, it's been a long day, I understand, but we've been speaking a lot about AI, but we are yet to see that AI, and today you will see AI in this presentation as to like how it works, some real case situations. So first, addressing the elephant in the room, which is like, what is the existing problem? The legal research is in international arbitration is still painfully manual. So about 20 years back, when international arbitration legal research had to be done, one would have to go through the books in the libraries after several rows and several rows to find that particular book to address, to have access to that particular case. But after the internet era, it is no more the situation, and now AI is here to improve the efficiency furthermore. Previously, it was time-consuming, expensive research, and like how I shared, it's limited accessibility. But now it is getting better and better with AI. So in the coming slides, I'll share with you like some of the examples. You can see how arbitrators, how legal professionals, corporates, and institutions across the globe use AI tool. And so here it is. First, before showing examples, how is the adoption rate currently at the market? Because we've heard both the sides, which is like pros and cons with respect to international arbitration, but adopting AI in international arbitration. But what is the ground situation? How are the arbitrators currently seeing AI? So here are some of the examples. For example, Bernardo Cremades says, in the past, we might have spent over $100,000 just in billable hours researching for the right arbitrator. But now it is all in a few clicks and a few minutes. I'm not trying to say this can exactly replace those manual hours, but it is improving the efficiency and decreasing the cost. It is purely in that angle, I'm saying. And other testimonials include how AI enhances the legal services with efficiency and accuracy. And one more thing from the morning I've been seeing is that like people usually associate the likes of generic Gen AI tools such as ChatGPT. But the essence of high quality Gen AI tools are spoken less of. Thanks to Gloria as well, insisting on how the ISO 27001 matters in international arbitration. These are the ones that touch upon points such as the confidentiality and how the documents will not be posted on the internet or for the algorithm to learn by itself. And you can read here as well as to how the arbitrators are adopting AI across the globe. And a few more examples. So now coming to the one that I had said, which is that in terms of real case scenarios, how does AI works? Is that like it helps in drafting, it helps in case analysis, it helps in strategy. Drafting in the sense like the AI will not exactly replace a human to give a complete draft. No, that is not the role of AI. The role of AI is to give a tentative copy, a draft copy of the final document, and from there on, a manual intervention has to be there to refine it and give a final edits. This helps in saving a lot of time. There are several tools, not just Yusmundi, some of them are mentioned here. So coming to the ones that I had mentioned, of course, there are ethical and strategic implementations, but considering the lack of time, I'm going to the next real-time examples. So with respect to emerging hubs, what are the differences that like some of the emerging hubs such as Uzbekistan, such as the Asian region or the African region, the difference is that by adopting AI, it fills in that gap. I mean, it bridges that gap, and especially, for example, there are big law firms that have significant advantage. And the big challenge for smaller law firms is there's a huge barrier for smaller law firms to enter into this international arbitration area. And that is exactly where the AI comes into play, and it bridges that gap. And for example, it also supports the legal system completely. It's just not about the practitioners. It also supports corporates dealing with international arbitration or institutions dealing with international arbitration. So some of the recommendations that I have are that the AI has to be adopted mindfully. So this is more like a product, just like any other revolutionary product that comes into the market every once in a while. So for example, when internet was released, or for example, as simple as when a pen was invented, or when a car was invented, there have always been skepticisms, assuming that what if it is used for the wrong purpose? What if it goes wrong? But by now we understand that AI is here to stay. AI will be there in international arbitration. It is up to the users to use it in a mindful way, because this AI increases transparency and traceability. There have been instances, of course, from the morning we've been talking about issues where the AI tool has hallucinated. It has given out cases which were not there in real life situation. That is exactly where specialized tools come into play. So again, the onus, the accountability is in the part of the user. So that is the recommendation, even from the perspective of the legal tech firm that we submit, is that the user, the legal practitioner, should ensure that with a manual verification, even if the AI does all the works. And the other recommendations that we provide from legal tech's point of view is that like the arbitrators have to be trained in the AI technology, and lawyers will also have to be trained, because as shared in the previous panel as well, a lawyer will never be replaced by AI, but a lawyer who uses AI will probably be replacing a lawyer who is not. So that is how the situation will likely turn out in the next coming days. And we also recommend that we also encourage institutional guidance on this particular topic. Yes.
you so much, Arjun. In the interest of time, we'll pass the floor to Ulrich. We are absolutely delighted and honored to have another leading institution together with us today. Ulrich, we're aware that the ICC is also undertaking a number of technology-related initiatives, and we're eager to learn more. So the floor is yours.
Thank you so much. The ICC has been pioneering international dispute resolution for over 100 years. In 1923, the International Court of Arbitration was founded, just more than 100 years ago, with the founding vision of promoting world peace through world trade and providing businesses with peaceful and efficient ways to resolve their disputes. And so, since we've been around for more than 100 years, we've witnessed quite a few technologies. Our digital transformation began a few decades ago, in the early 1980s. Up until then, everything we did was papers and binders. Now, I must admit, I did not know what a telex was until recently. I thought fax was the most outdated technology that I could imagine. Now, there's a thing called telex, and at one point, it used to be something very, very modern. I understand that it's essentially a typewriter connected to a phone line. So this was the latest trend in the early 80s. This is what we introduced. It continued with fax, it continued with emails, and each step was perceived to be revolutionary at the time. But what we are experiencing now, artificial intelligence, is perhaps the most significant transformation yet. So in 2022, 3 years ago, we launched our Case Connect project. Case Connect, a comprehensive redesign of our case management systems to provide a one-stop case management solution. And just this year, we launched a new version of Case Connect, powered by Opus 2, which is now marking the new way of how we are interacting with technology. So Case Connect is essentially a one-stop case management solution that provides a platform for arbitrators, tribunals, and the ICC Secretariat to connect. It's a single integrated system for end-to-end case management. It has dedicated portals accessible to external users. It integrates in the back end with SAP for efficient processing of financial matters. And of course, it has an e-filing portal that allows you to streamline document submission and submit documents efficiently. So this Case Connect platform lays the foundation and constitutes the building blocks upon which we are building our AI capabilities. Now, speaking of AI, let me share our strategic approach to AI. It's essentially, our AI policy is essentially streamlined and organized into 4 different workflows. First, policy and advocacy, ensuring the responsible use of AI in dispute resolution and providing institutional guidance. Playing an adversary role for the ICC network and our national committees. Thinking about the direct application of AI in arbitration. And finally, ICC productivity tools and enhancing our internal organizational efficiency. And to support this agenda, we hired all kinds of tech people, AI people over the past few years. And so you may be wondering, what does that all mean in practice? And we started and conducted a productivity pilot program internally, where we tested AI tools with 40 ICC headquarters staff over a period of 4 months. And the results truly exceeded our expectations. So I'm not going to go through all the numbers here in the interest of time. But the significant majority of the participants reported that AI added value to their work, that it increased the quality of their outputs, that it saved time, and that it had a positive impact on their well-being. Now, the main use cases of this pilot project included things like internal research, translation, document summarization, meeting preparation, and certain type of marketing content generation. But crucially, and that's important to note, all arbitration case management data was excluded from that pilot. And that was not just a technical decision, but that's actually reflective of our fundamental approach at the moment towards AI in arbitration. So while we're still in the early phase of AI development, we're being very cautious about the potential use of AI by arbitrators and institutions when it comes to actual casework. But while we are cautious about AI in decision-making, we're very excited about the potential to enhance other aspects of dispute resolution. And this brings me to what makes ICC uniquely positioned to lead this transformation. Now, at the heart of our ecosystem are our 29,000 cases. Since the ICC Court was founded in 1923, we've been administering more than 29,000 cases, and that represents a genuine data gold mine. Now, while we are still in the early phases of understanding what we are going to do with that data, it is already clear now that we will always maintain the strictest confidentiality standards, that we would never sell that data to any AI provider to train the AI models, because we realize that confidentiality is a legitimate expectation of the parties, and we hold that data in trust for the parties who put their confidence in ICC arbitration. So, while we think we are uniquely positioned to develop AI solutions that make dispute resolution more efficient, we must never lose sight of one fundamental truth that I think is underlying our work, and that is the human element. Last year, parties were conducting ICC arbitrations in over 140 different countries. They included private companies, but also 20% of our cases involved states or state entities. So there is a remarkable geographic and cultural diversity between the parties who use ICC arbitration, and that prompted us to take a step back and to ask ourselves, what does this mean for how we approach dispute resolution in an increasingly AI-driven world? So we conducted a comprehensive study amongst business decision makers on the human and cross-cultural implications and dimensions of the B2B journey, of which disputes are just a small part. And what we discovered, we found very fascinating. Business relationships are a deeply emotional journey. Our research showed that emotions fluctuate dramatically throughout the whole B2B life cycle journey, from positive during the initial engagement to strongly negative during friction and disputes. We dispute lawyers, we arbitral institutions, we often join these relationships at their emotional low point when frictions and challenges arise. But there's more to understand why disputes arise in the first place. When we asked business leaders why contracts fail, the response was perfectly split. 50% blame the contract or the scope of work, while 50% blame the people or the business relationships. So this tells us something fundamental. Disputes are human problems. And while AI can help us process information more efficiently, analyze patterns, and streamline procedures, there will always be a place for human judgment, cultural understanding, and empathy in resolving these disputes. And this is why we at the ICC, we are not just focused on arbitral awards. We actively encourage amicable resolutions even after an arbitration has been initiated. We offer mediation and other ADR services to help parties reach an amicable resolution to their dispute. We have a strong focus on facilitating settlement also during the arbitration process, because we understand that preserving business relationships and managing the human factor often matters as much as resolving the legal issues. So this human-centered approach guides everything that we do, including our plan on how we plan to move forward with our AI integration. As we continue this journey of our AI integration, here's what you can expect. The ICC Commission on Arbitration, our think tank, has an AI task force that will be releasing important updates and guidelines. We will publish thought leadership pieces on our website, and we will continue to provide dispute resolution digitalization updates throughout this and next year. With that, I'll conclude, and I say that the integration of AI into our ICC's dispute resolution services represents an evolution of how we serve the global business community, and it's about enhancing efficiency, but while always preserving that human factor that makes effective dispute resolution possible. Thank you.
We are very grateful, Ulrich, for a very interesting presentation. And to conclude, I'd like to add that one of the objectives of the forum is to collect expert recommendations to the Ministry of Justice as well as other stakeholders. We've heard from Arjun a number of proposals and recommendations. You've had that on the last slide. But we would be delighted to hear from any of you if you have any other regulatory or any other recommendations to the stakeholders. Any? Yeah.
Well, I don't think I'm in the best position to provide regulatory advice to a government. But
Recommendations, not advice, recommendation.
But I will say that I think in a rapidly changing environment as the current one, it's advisable to observe, maybe not necessarily be the first mover, and be careful about how you approach AI.
Yeah. And to add mine, I would say, in developing the framework and the regulations, I think we just need to bear in mind, especially for arbitration, the tenets that arbitration stands on, which is principles of fairness, due process, confidentiality, and accuracy. So I think once you have principles undergirding all the measures, I think they will enable you to have a very robust framework.
Thank you. Dr. Boscha, anything else to add? No, we're good. Well, can we please give a big round of applause to our distinguished panelists, as well as exceptional translators. Thank you so much. You are always the best. Thank you.